to arrive, I have a few announcements to make. For those who want to utilize the Twitter handle is the hashtag Jealous Review 202, and you are on. I also wish to inform you that the social media is live. The links will be put on the notes board as we go. We are reminded that today the theme is empowering the people, building trust, and upholding rights. Very, 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 very important. And of course, we note that while this is the 27th joint review meeting, this is the first review under the program approach. So we hope to harness a lot from this review, and we continue to interact. Meanwhile, band continue to entertain our guests. Thank you. Another piece of information, anybody who wants to take a branded picture, that's our photograph ground. Don't miss the branded picture so that history will always reckon at what has taken place today. Thank you very much. That when he comes in, we give him a standing ovation. And as I had said, we shall start with the anthems, then will be prayers, and we shall proceed by informing you thereafter. The band, you can continue on a low note until our chief guest arrives here. Thank you. As you cannot really see the cameraman probably in certain corner, that tells you our chief guest is with us. May you arise and receive our chief guest for today's session. My Lord, the Honorable Chief Justice of Uganda, you are welcome. I would request that we keep standing as we sing the anthems. We keep standing, sir, and I would really wish to call upon Madam Jerimo for prayer. Then we could take our seats finally. Prayers.
Let us humble ourselves for a word of prayer. Heavenly Father, we thank you for this new day and the gift of life. We come to you today asking for your guidance and wisdom as we begin our 27th annual review for financial year 2021-2022. We pray for our leaders that you grant them wisdom, knowledge, and intelligence to excel. Help us, Lord, to engage in meaningful discussions for the development of our country. Enable us, Lord, to grow closer and strengthen the chain-linked system we have cherished for the past 25 years as we serve the people of Uganda to ensure service delivery for all, improved service delivery for all. I pray all this for God and my country.
Thank you very much. I request that we take our seats. My Lord the Chief Justice, Honorable Ministers, my Lords Justices and Judges of the Courts of Judicature, Honorable MPs, the Head of the European Union Delegation in Uganda and Chairperson of the Access to Justice Sub-Program Development Partners Group, Your Excellencies, Heads of Diplomatic Missions to Uganda, Honorable Members of Parliament, Heads of Access to Justice institutions, members of the steering and technical committees, members of the district chain-linked committees, distinguished invited guests in your respective capacities, media, ladies and gentlemen. For the 27th time, we are here as a team to review performance of the formerly Justice and Law and Order sector and now Access to Justice sub-program. We are excited to be here, and we're excited to receive the proceedings. My Lord, today's meet is summarized in 3 sessions. The first session will be chaired by the Honorable Attorney General. Will officiate. One of the main activities we will officiate is about launch of the Access to Justice Report 2021-2022. The second session will be chaired by the Honorable Minister of State for Internal Affairs, and it's about presentation of the Access to Justice Annual Performance Report 2021-2022, and the co-chair will be the Solicitor General. My Lord, the third session will be chaired by the Director of Public Prosecution, and this will be mainly to conduct the plenary activities, and thereafter we shall see the day off. Without wasting any more minute, my Lord, permit me to invite the chairperson of this first session, the Honorable Attorney General, to take charge. Your permission, sir.
The Honorable, the Chief Justice of the Republic of Uganda, Honorable Ministers present, my Lords, Justices and Judges of the Courts of Judicature of Uganda, the Head of the European Union Delegation, I have been told to go to a higher point, that I was a bit low here. So you can see these titles come with different things now. There are people down there and there are us up here. My Lord, the Honorable the Chief Justice, Honorable Ministers present, my Lords, Justices, Judges of Courts of Judicature, the Head of the European Union Delegation in Uganda and Chairperson of the Access to Justice Sub-Program Development Partners Group, Your Excellencies, Heads of Diplomatic Missions to Uganda present here, Honorable Members of Parliament, Heads of Access to Justice Institutions, Members of the Steering Committee, Members of the Technical Committees, Members of District Chain Link Committees, distinguished invited guests in their respective capacities, but more importantly, the generals present, because now you know I'm also a general of sorts, so I have to give a special recognition to the generals present. Ladies and gentlemen, I welcome you all to the 27th Annual Access to Justice Sub-Program, Government of Uganda Development Partners Review. This year's review is being held against a backdrop of a challenging year, the aftermath of the COVID-19 pandemic, which had globally challenging phenomena, socially, economically, and politically. More specifically, the pandemic created unprecedented challenges and demands on the access to justice community, but also tested the resilience and resolve of our coordination and collaboration model. I am proud to note that in the face of such challenges, our decade-old coordination structures and mechanisms remain firm and intact. Our review today is being held under the theme, Empowering People, Building Trust, and Upholding Rights. The theme is aligned to the National Vision 2040 that seeks to consolidate the principles of governance, including constitutional democracy, protection of human rights, the rule of law, government effectiveness and citizens' participation in development processes, and peace and security, among others. This also in line with the NRM Manifesto 2021-2026, as well as the National Development Plan 3. This is, of course, based on the NRM 10-point program. President Eisenhower once said, "Peace and justice are two sides of the same coin." Let's remember the need for both peace and justice, not just one of them. As moderator for this first session, I particularly wish to welcome the Chief Justice to this annual review. Allow me to also welcome in absentia the Minister of Justice, who advises that he's on his way, who is the chairperson of the sub-program leadership committee. Colleagues, ministers, all of you in your respective capacities, you're most welcome. When we started this term of office, the President advised us to have a cogent approach, a whole-of-government approach. I think the JELOS program has shown the first model of a program approach to developing a sector. And we encourage you to run this whole-of-government approach across all sectors of government. I also welcome our development partners and JELOS stakeholders. It's my hope that today we shall have meaningful and engaging discussions on a broad spectrum of all issues that have a direct and indirect impact on the access to and delivery of justice in our country. We do appreciate the role of our development partners and value your continuing partnership. Your presence here today is a demonstration of the strong partnership that we commonly share. I join others to welcome and thank you, our development partners, for their unrelenting support over the years. We sincerely appreciate your commitment to the Access to Justice sub-program, going back over 20 years from the formative years of the sector-wide approach. Stephen Covey, a celebrated author, for those of you who have read his 7 Habits of Highly Effective People, said, "When mutual understanding and respect are present, the spirit of synergy inevitably starts to develop." And I think that's what the JELOS group has been able to demonstrate. I wish to welcome our friends from other programs for this review. We hope you will learn 1 or 2 things and teach us 1 or 2 things to make our program better and make yours better. We are partners and comrades in this cause, and we look forward to strengthen inter-program partnership going forward. I once again thank you all for honoring this invitation and look forward to your active participation in this review. I thank you all for listening to me, for God and my country. Mr. Beine, now that I'm in charge, I am allowing you to take the podium and lead us through the rest of the program. Thank you all.
Thank you very much, sir. Can we put our hands together for the Honorable Attorney General? A very big one. Sir, I agree with you. Joint reviews are healthy dialogue to exploit the best solutions for the existing challenges. And the next speaker is the welcome remarks by the Permanent Secretary, Minister of Justice and Constitutional Affairs.
My Lord, the Honorable Chief Justice of Uganda, the Honorable Attorney General, Honorable Ministers here present, my Lord Justices and Judges of the Courts of Judicature, Your Excellency, the Head of the European Union in Uganda and the Chair of the Access to Justice sub-program, development partners, group members here present, Your Excellencies, Heads of Diplomatic Missions in Uganda, heads of Access to Justice institutions, members of the steering and technical committees, all of you distinguished guests ladies and gentlemen, a very good welcome, and thank you for being here. My name is Robert Kasande, Permanent Secretary, Minister of Justice and Constitutional Affairs. On behalf of the Access to Justice Sub-Program and on my own behalf, it's my honor to welcome you to this 27th Joint Steering Group Members Annual Review 2022. I'm very delighted to be here, and I'm very happy that you've set aside time amidst all your busy schedules to participate in this very annual review. I welcome and thank all our development partners, civil society organizations, and all stakeholders for honoring our invitation. I sincerely extend my deep appreciation to the members of the Access to Justice Steering and Management Structures for your presence and having attended this review. I commend all the Access to Justice Sub-Program institutions and the Administration of Justice Program for participating in developing this report that we are going to review today. The sub-program is coordinated by the Secretariat under the leadership of a Senior Technical Advisor. Allow me to commend the Secretariat for coordinating the organization of the review and for linking with all our development partners. In the same vein, I acknowledge the contribution of the Administration of Justice Program to realization of access to justice in Uganda. I affirm that the Access to Justice Sub-Program and the Administration of Justice Program is a strong chain of justice which can never be broken. The continued strengthening of the partnership and collaboration of the Access to Justice actors is very key and very important for improved service delivery and realization of access to justice by all Ugandans. My Lord, the Honorable Chief Justice, and all colleagues, once again, I welcome you all, and allow me to wish you a very holy Christmas and a great 2023 for God and my country.
Thank you. Thank you very much, sir. I think we need a little bit heavy applause for those remarks. In a special way, I would wish to request the Honorable Minister of Justice and Constitutional Affairs to take his seat. Sir, welcome. Next on the program is the remarks by the Jealous Development Partners, represented by the European Union Head of Delegation. Sir, you are welcome.
Thank you very much. It's great to be here. And before I give my remarks, I would like to recognize the presence of our dignitaries. So I start by greeting His Lordship, the Honorable Chief Justice, the Honorable Minister of Justice and Constitutional Affairs, who is just taking his seat, I think. The Honorable Attorney General, Honorable Minister of State for Internal Affairs, the Solicitor General, the Honorable Justices and Judges of the Courts of Judicature, Director of Public Prosecutions, Excellencies, Ambassadors and Heads of Diplomatic Missions present, colleagues, Honorable Members of Parliament, Chairpersons of Constitutional Commissions, Permanent Secretary, Ministry of Justice and Constitutional Affairs, Permanent Secretaries of Ministries present, and Secretaries of Commissions present, Inspector General of Police, Commissioner General of Prisons, representatives of development partners, members of the media, representatives of civil society, and last but not least, members of the prison band. And I think, don't you think, yes. You made our mornings. You're definitely worth a great applause. Thank you very much. Ladies and gentlemen, I'm honored to deliver these remarks on behalf of the Access to Justice Development Partners Group. My Lord, today's review is yet another valuable opportunity for us to jointly reflect on the performance of the Access to Justice sub-program in its mission to empower people, build trust, and uphold rights. When I took up my tour of duty recently, I was briefed on the good collaboration between the Access to Justice Development Partners Group and the government, and its institutions over all these years. Therefore, I convey our sincere gratitude for the opportunity afforded to us to once again engage constructively. My Lord, there were several significant achievements registered during the period under review, and I would like to highlight a few. Building on progress in past years, there is now a one-stop frontline service point in 83% of the districts, which is contributing to increased access to justice and satisfaction by the population, and I congratulate all of you for this. In terms of infrastructure, the development partners would also like to laud the start of the construction of the Jalos House, which will be a landmark building in Kampala and which will lead to closer collaboration amongst the Access to Justice sub-program actors and ultimately improved service delivery to citizens. I wish you good luck with the finalization of this flagship project. We also positively note an increased percentage in case disposal rates underpinned by disposal of a substantial number of cases, especially in lower courts and in the anti-corruption court division. Complementing these achievements was high conviction rates that demonstrated increased efficiency and competencies at various phases of the criminal justice chain. A very impressive work indeed. In addition, my Lord, we note the increased strengthening of business registries and the accelerated pace of automation of business processes within the Access to Justice sub-program institutions. The ability of the different systems to speak and connect to each other will result in improved efficiency in the delivery of justice, law, and order services, thereby building more trust and confidence of users. The report also highlights a significant drop in crime rates, and I want to commend all the security actors for this. We hope that this positive trend will continue, so keep up the good work that you are doing. My Lord, I would like to now turn to some areas which deserve further discussions and efforts. Although there are initiatives, the absence of a nationally funded legal aid scheme remains a significant impediment to access to justice, in particular for the poor and vulnerable persons. With the end of the democratic governance facility that was providing legal aid to some 90,000 Ugandans, we would like to reiterate our previous calls for a nationally funded legal aid scheme to support access to justice and promote the right to a fair hearing that is enshrined in the Constitution. As development partners, we would like to express our continued commitment to this important aspect of access to justice. In this regard, we would also like to stress the importance of the National Legal Aid Bill, which we hope will be enacted soon. My Lord, the annual report reveals that suspects spend a considerable period of time on remand and that congestion in prisons and remand homes is acute, a situation that has been worsening in successive years. A concerted action and reforms are needed to address these challenges. My Lord, distinguished guests, case backlog remains a significant issue. Although some gains are noted, the problem persists, thereby eroding trust and impeding access to justice, law, and order services. In particular, the development partners would like to renew their call for an expeditious disposal of backlogged cases, in particular, a speedy trial of cases of sexual and gender-based violence and juvenile cases. My Lord, I would like to make some observations on outcome 3, which provides account of interventions undertaken to strengthen compliance with the Bill of Rights and tackle corruption within the sub-program institutions. Programs on Outcome 3 has historically been the most mixed, and this is the same for the period under review. As stated in the report, and I quote, "Torture consistently remains the most reported human rights violation over the years, although with a declining numerical count compared to the baseline year 2016-17. The second most reported violation is denial of personal liberty, and in this regard, we would like to call for the perpetrators of human rights violations, including those related to the November 2020 events, to be held to account and ensure justice for victims. In addition, we would like to emphasize the urgency for finalization and implementation of the National Action Plan on Human Rights, a process that in our view has stalled. We also note with concern reports about resurgence of irregular arrests. We hope that the implementation of the recent declaration of the Honourable Minister of Internal Affairs to end arrests before investigations are complete will curb violations of the rights of suspects. And we wish you good luck with this important ambition. My Lord, as I conclude, we would like to reiterate that the effective and close collaboration between the Access to Justice sub-program and the Administration of Justice program is essential. The participation and the leadership of both programs in this review show your commitment to this collaboration. So with these remarks, ladies and gentlemen, I wish you fruitful deliberations during the course of the review. Thank you very much for your kind attention.
A big hand of applause to these critical statements that we need to internalize. My Lord, we are all honored to be here, but in a special way, permit me to recognize the presence of the following: the Ambassador of the Royal Netherlands Embassy, the head of office, Austrian Delegation Corporation, Deputy Resident Representative, UNDP, UN Office of the High Commission for Human Rights, UNICEF, yes, UNODC, Dr. Livingstone Sewanyana of Foundation for Human Rights Initiative, Dr. Sylvia Nambiru of RASPNet, Miss Margaret Sekaja, Human Rights Center for Uganda, and others to follow. Since His Excellency liked the Prisons Band, give us one treat before we proceed. Thank you, Band. My Lord, we all agree that consistency contributes to measurable value of great performance. Having been coming together for the last 27 times marks a great position to us in terms of performance, and one registered word in everything all the time is called progress. So we are glad to share that word, progress, and we hope we shall continue to progress. Next on the program, my Lord, is the remarks by the Minister of Internal Affairs. You're welcome, sir.
The Honorable Chief Justice of Uganda, the Honorable Ministers present, Lords, the Justices of the Courts of Judicature, the Head of the European Union Delegation in Uganda, and Chairperson of the Access to Justice Sub-Program Development Partners Group, Excellencies, Heads of Diplomatic Missions, Honorable Members of Parliament, Heads of Access to Justice Institutions, members of the steering and technical committees, members of the district chain-linked committees, distinguished invited guests, ladies and gentlemen, good morning. I'm here on behalf of my senior minister who sent his apologies, and I'm delighted to be invited to attend this very important meeting of the 27th Joint Government of Uganda Development Partners JILOS Access to Justice Annual Review. I want to thank you, the organizers, and all the participants from the onset. This annual review takes place at a time when government has just finalized the midterm review of the third National Development Plan, NDP3, which we are currently implementing. As you are aware, government agreed that the current NDP3 adopts an integrated program planning approach to focus implementation on delivery of common results by addressing persistent implementation challenges resulting from uncoordinated planning, weak harmonization and linkages, and working in silos. Consequently, different institutions now belong to different NDP3 programs. Despite belonging to different programs, I'm delighted to say that our institutions have been able to quickly adjust and respond to the new demands and have continued to work jointly. In this regard, we should adopt a 3C's strategy, which is coordinate, communicate, and collaborate, as a driver of the effective service delivery we all seek. Coordination is an important element of if the delivery of access to justice services is to be achieved. Proper and effective communication is critical in what we do and the end states we desire to achieve. We should ensure that we share information among ourselves and confirm that it is received and properly understood. Collaboration is a levered means to an end. Let us not have core programs go ahead without seeking the input from others and discussing that input openly. Coming together is a beginning, keeping together is progress, working together is success. Most of you here began together as JILOS, Justice, Law and Order sector, and my humble appeal is that we continue working together even when we subscribe or belong to different programs under the NDP3 programmatic approach. Fortunately, the NDP3 programmatic approach allows government ministries, departments, and agencies to plan, design, and implement programs that cut across jurisdictional boundaries as well as sectoral mandates. Lord Chief Justice, participants, where I used to trade in the military, we have the mantra of ends, ways, and means as our aid memoir, and it guides our approach to to business. It applies here as well under JILOS. The ends we seek to achieve are common, so too the means that we use, or the resource pass, and the ways may differ only in detail of our specific but complementary roles in ensuring easy access to justice for our people. Our focus, therefore, must shift to the citizens and people of Uganda. This is the relevance of the theme of this year's annual review of empowering people, building trust, and upholding rights. The critical questions to ponder must revolve around the three strands of this theme. Namely, have we empowered the ordinary people enough to know where to seek justice services? Are Ugandans able to consciously, independently, and purposely navigate the different service points in our justice system as they claim and protect their human rights? Have we lowered some of the access barriers in terms of distance and procedural complexities? B, have we built the critical trust levels that depict citizens' confidence in our justice system from the point of entry to exit? What impression resonates in the minds of an ordinary member of the public when they engage with our justice system? C, as we deliver these critical justice services to the public, are we upholding human rights? Have we sufficiently mainstreamed the human rights-based approach to guide our public service across the entire justice chain? The answers to these questions above are resident in the work we do, and I believe this should be the lenses with which we assess our progress moving forward. In the case of human rights, our consistent position as government has been that any breaches should be dealt with in accordance with our laws by ensuring that those responsible are held to account. Ladies and gentlemen, we need to note that we live in a dynamic environment in which the demands of justice, law and order, service institutions are numerous. Accessing justice is part of the foundation of strengthening our nation. We have made advances in addressing civil areas such as reducing the distance people traverse in search of justice services, simplifying and clarifying processes, identifying low-cost options for service delivery, and reducing the cost of access, as well as developing and employing automation and digital services to enhance the speed and quality of service delivery. As we deliver justice in this new dispensation, I beseech all of you to note that even under the program-based approach, we can still coexist as JILOS institutions. I wish to welcome and thank all our partners across government and by extension the development partners to this important meeting. Although you have called a JILOS review, it touches many core aspects of governance. This illustrates and reflects the work and interest of the entire government as far as the rule of law and delivery of justice are concerned. We are all intertwined in this effort, whether it is in the shared delivery of services such as health, education, water, or in the provision of financial and technical support services. We look forward to renewed and strengthened partnerships through and under the auspices of JILOS. I appreciate all those involved in the business of dispensing justice, law and order services in the country, notwithstanding the ever-increasing needs and demands. I thank you all for sparing time to come and participate, engage, and provide solutions to strengthen access to justice for everyone in our country. With these few remarks, I wish you fruitful deliberations for God and my country. I will at this juncture want to say that I may not stay the length of presiding over session 2, but my PS, Lieutenant General Musanyifu, will do the needful with your permission. I thank you for listening. God bless you.
Thank you very much, sir. Can we give a bigger volume of the hand clap for the Honorable Minister? My Lord, we agree that all these comments being made are actually touching the theme of today's meeting, empowering the people, building trust, and upholding rights. Like I said previously, that we are all very welcome here, but my Lord, permit me also to mention a few individuals here who have also been playing a key role in this program. We have the Permanent Secretary, Minister of Justice and Constitutional Affairs. He's recognized. A hand clap. We have the Permanent Secretary, Minister of Internal Affairs. We have the Secretary to the Law Reform Commission. And my Lord, when I was a very young man, there is a gentleman I think all of us admired. And he's none other than Ambassador Francis Butajira, Chairperson, URSB. He's been an inspiration to very many. My Lord, we also have the Chairperson of Uganda Law Reform Commission. Amidst us is the Director of Public Prosecution. My Lord, we also have the Chairperson, Nira. Amidst us, we have the Chairperson of Uganda Human Rights Commission. We have the Deputy Inspector General of Police. We have the Deputy Commissioner General of Prisons. We have the head of the Anti-Corruption Court. We have the Chairperson of the Leadership Code Tribunal. We have the Chief Judge of the Industrial Court. We also have the Solicitor General in his capacity. My Lord, with your permission, we go to the next speaker, who is the Honorable Minister of Justice and Constitutional Affairs, to give his remarks. You're welcome, sir.
My Lord, the Honorable Chief Justice of the Republic of Uganda, colleagues, honorable ministers, my lords, justices and judges of the courts of judicature, Your Excellency, the head of the European Union delegation in Uganda, and who is also the chairperson of the JLOS Development Partners Group, Your Excellencies, heads of diplomatic missions in Uganda, the heads of the JLOS institutions, our technical team who steer this program, distinguished invited guests, ladies and gentlemen, I apologize for sauntering in late. There was another meeting which I thought would end earlier, and I'm grateful to the Attorney General for being here to hold the fort. In our culture, which the Chief Justice is familiar with, when you arrive late after the big people have arrived, you miss the red carpet. You are supposed to sneak in from the back. And that's why I could not come straight to my designated seat. You are supposed to be shy. when you have breached ethical standards. That's very important. So shyness is important. My Lord, I am new in the portfolio that I hold, but I'm not new in the field of access to justice. I'm a lawyer. I was enrolled as an advocate in 1994. I have been arrested. I've been charged. I've been imprisoned. I have never applied for bail. I've also been sued. I have ever been visited by auctioneers and bailiffs. Basically, these are the things we are talking about. Things which affect us. Whether you speak in Swahili or a local language, whether you speak in Latin, it's about asserting rights and redressing wrongs. It is as simple as that. When I arrived at the Ministry of Justice, fortunately, the learned Attorney General had already done a lot of the donkey work to exercise his responsibility. Now, responsibility means ability to respond. All of us here are part of the solar system of justice. We are different planets, but at the middle of that, in the middle of our solar system are the people. And we all stay in our orbits. So I guess we have come here to put a mirror before our eyes and ask ourselves, how do we look? We all play different roles. I can only speak for myself and probably the Attorney General. The Chief Justice will speak for the judiciary. The police will speak for the police. The prisons will speak for the prisons. And our international development partners will also speak for themselves. After all, the world is now flat. We are interconnected. We are here to ensure that we do better, so that when we come back for the 28th time, we give ourselves marks. Of course, COVID-19 gives us some mitigating factors. It is now a hiding place for many governments. Oh, you know, because of COVID, we could not do this. Because of COVID, even donors, because of COVID, cannot give as much as they promised. All of us are taking cover under the general umbrella of COVID. Case backlog, COVID courts were closed. But we cannot use COVID as a reason forever. So I want to pledge on behalf of the Ministry of Justice, which I'm now the political leader of, and also as a lawyer, because as a lawyer, I'm an officer of the court. As an advocate, in a way, my leader is also the Attorney General, because he's the head of the bar. So when we are confronting the judiciary, we stand behind the Attorney General as lawyers. Law, justice, these are disciplines. the army, the police, the prison are referred to as the disciplined forces. Are they really disciplined? Okay, what is the discipline? The discipline must be based on the law, not anybody's opinions. So I have come to say, how about we start with some low-hanging fruits? There are things we can actually deal with. When I was a student, my teacher told me, Norbert Mao, when you go into the exam room, start with the easy questions that you know you can answer, because there are no marks for courage. The examiner will never reward you for spending all your time tackling a number that you cannot answer successfully. No examiner will say he deserves to pass because he really, really had the courage to tackle this difficult question. So I am here to list some low-hanging fruits. Number one, this question of torture. Your Excellency, the Ambassador, we acknowledge that there's torture. We acknowledge that people are imprisoned beyond 48 hours. We acknowledge. It's important for government to acknowledge. But that doesn't mean that thereby we become evil as government. We acknowledge all the bad things that happen. And it is our commitment to deal with them. The centerpiece of the commitment actually has been laid down by the judges themselves. Judges have said that torture taints prosecution. The government will never successfully prosecute a case where there's torture. This is what the court said in the case of Uganda versus Robert Sekabira. It was Justice Ralph Ochan, and he said, "We cannot stand by and watch prosecutions mounted and conducted in the midst of such flagrant, egregious, and malified violations of the Constitution, and must act to protect the constitutional rights of the petitioners in particular, and the citizens of Uganda in general, as well as the rule of law in Uganda, by ordering all the tainted proceedings against the petitioners to stop forthwith, and directing the respective courts to discharge the petitioners." In another case, which was now handled at the Constitutional Court, the case of Dr. Kiza Besigye versus Attorney General, the Constitutional Court said, "This court cannot sanction any continued prosecution of the petitioners where during the proceedings the human rights of the petitioners have been violated to the extent described above, no matter how strong the evidence against them may be. No fair trial can be achieved, and subsequent trial would be a waste of time and an abuse of the court process." Other philosophers, significantly Edmund Burke, said, "Law and arbitrary power are in eternal enmity." Therefore, sitting behind the desk of the Minister of Justice, I'm not afraid to tell you that we are on the same side. Truly. You heard the Minister of Internal Affairs saying he is tired of rogue elements who kidnap people, disappear them. It was the Minister of Internal Affairs who is in charge of the police. Just to demonstrate to you the seriousness with which we take these matters, recently the cabinet appointed a standing committee of the Cabinet on Human Rights, which I'm honored to chair. The Attorney General was supposed to co-chair, but then he said he is the most sued person. I don't know how his family sees him, because everybody sues the Attorney General. I hope they don't think it is personal. The Minister of Internal Affairs deputizes me. We have the Minister of Foreign Affairs. We have the Minister of Information, Minister of Defense. It's a committee of 7 cabinet ministers. We have also been given permission by the President to address the National Security Council, to talk to them about the rogue elements who taint the name of our disciplined forces. Therefore, we are determined to ensure that everything is done according to the law. We also have met as the top leaders of the ministry, myself, the learned Attorney General, the Deputy, the Permanent Secretary, and key technical people. We have agreed to invite the promoters of the National Legal Aid Bill, the promoters of the Human Rights Defenders Bill, so that we have straight talk about legal aid. You have called for state-funded legal aid. Now, legal aid actually is not just for the poor. Let me disabuse people. When you are considering who qualifies for legal aid, the key thing is affordability. Now, it is not enough that you cannot pay. The real consideration is what you forego by spending your money on legal proceedings. I know this for a fact because I worked for the legal aid project of the Uganda Law Society, and I was given the assignment by the then president of the Uganda Law Society, Justice Solomon Balungi Bosa, to open the legal aid project, the Northern Uganda Regional Office. We are not afraid to have frank discussion about the financial implications. All governments are terrified of making promises they cannot keep because you lose elections when you do that. Your Excellency, excuse our caution, because unlike you, for us, our posters will be all over when we are standing for elections. Your face will not be there in the constituencies. By the time we make the move of supporting this bill wholeheartedly, we must be able to backstop ourselves. Now, that is where the partnership is critical. I will invite you for that meeting so that you listen in. We want you to be observers in the conversation on legal aid so that you understand our reservations. In the same breath, I want to salute the judiciary. Through justice centers, of course, judges are not going to appoint lawyers for anybody. But the judges of their own motion have decided that those who come to court should be assisted in a special way. With the help of partners, notably the Austrians, who don't even have a real embassy here, they have something which I don't know how it is described diplomatically, but they have a footprint. They have managed to support the judiciary to create these justice centers. So, NGOs are also standing in the gap. And I want to state it clear here. There has been a lot of conversation about civil society. And many people think government and civil society are at war. Your role as civil society is to stand in the gap. You do the things that government cannot do. There has been some bad blood occasionally between the civil society, and it has been blown out of proportion to the extent that now some people think that the government is an enemy. But that is largely because of language. In government, we have tried to restrain those who speak for government not to refer to NGOs and civil society organizations as the enemy. Because when you call somebody an enemy, it means you want to destroy them. It is as simple as that. Why should I call you an enemy and I leave you alive? Also, we advise the civil society and the NGOs not to use our language of politicians. You know, for us, we use superlatives. You are NGOs. We expect you to have, we don't expect you to be neutral, but we expect you to be non-partisan and impartial. But now when you hear NGOs talk about government and they start using the language of politicians, the junta, the dictatorship, then definitely you are now in our field. You have now entered our, they say, if you enter the dance of monkeys, their tails will touch you. Because lions dance by waving their long tails. So the tails will brush your face and you'll be very irritated. So don't enter that dance of monkeys. NGOs, please, don't use our language. For us, we are free to call each other dictators, junta, because it is a fair game. We are in the arena. That is for us. Don't join that game. It is not good for you. We are insisting that those who speak for government in the same breath don't also refer to you, for instance, agents of foreigners, and so on. We want to speak about you when we have evidence. Receiving money from foreigners does not make you an agent of foreigners. Even the Uganda government receives money from foreigners. Does that make us agents of foreigners? We borrow money from all over. After all, what is money? Money is a piece of paper and figures on a computer. That's what money is, actually. So we hope we will rebuild the relationships. We are also determined to share with our international partners the truth of what is happening in our country. All countries have their demons they must wrestle with. You wrestle with your demons. We will also wrestle with our demons here. We have demons. So there's a need to have proportionality. We have political actors who go around saying things that are untrue. Recently, you had accident victims being paraded in Nairobi as victims of torture. So it is important to also interrogate the credibility of your sources. I can tell you, in my life, I've been a campaigner against many government policies. And I've gone to US Congress, I've addressed the Irish Parliament, I've been to the European Parliament. I've never told a lie. Because I expect my government, and it is the only government I have, the government of Uganda. Even when I go to mobilize a US senator, the US senator is supposed to tell my government to do something that helps me. Not to make the government feel like I no longer believe in it. Because if I don't believe in the government, then it even has many excuses not to serve me better. These are the contents of my statement because I'm the political head of the ministry. The technical head is the Attorney General. He's the one who runs the government chambers. So I thought I should talk about the elephant in the room, because I know many of you are shy to talk about these things, and you are not going to talk about them because you are nice, you are diplomats, some of you are civil servants. But when I look at your faces, these are the things you want us to talk about. Corruption in the judiciary. You will be fearing the Chief Justice. I have talked to the Chief Justice. And by the way, one of the best ways of knowing someone and getting closer, of course, I've known the Chief Justice for a long time, but there's no better time to have an honest and good conversation than when you are traveling together. So I hope some of you will become my traveling companion sometime. I traveled with General Muhoozi David one time to Zambia. We talked a lot. We disabused ourselves of many biases. So I asked the Chief Justice about corruption. First he laughed. And he said, you know what? Money is collected on our behalf, but sometimes we don't see the money. How will a judge know whether a court clerk is collecting money on his behalf? Truth be told, there are some bad eggs. They need to be identified, isolated, confronted, and paralyzed. The Chief Justice told me a story of a clerk who went to the desk of a judge and saw a finished judgment, and the judgment was clearly in favor of one side. This clerk, militant and greedy, went to that successful party and said, you know what? I have peeped into your file and things can be very, very bad. But for some inducement, financial inducement, we can tilt the scales of justice in your favor. So this person gave the money, expecting the money to be taken to the judge. The judgment was some time ahead. In the meantime, of course, judges also read and they talk and they learn new things. This judge discovered a very important authority, which forced him to change his mind completely. So he went and changed the judgment. Now it was the other side winning. So this fellow who had given money to the clerk came confidently, very smart, the way I'm smart, sat in the courtroom, expecting that there will be a party afterwards. And he was, of course, nodding knowingly, looking at the judge in the eye, saying, you know, I gave you something, therefore, give me my dues. So the judge read the judgment. You know the way judges read. They take one issue, they push it that way, they collect it and dump it this side. And on the one hand, on the other hand, in this case, in that case. Finally, the verdict was totally against the fellow who had parted with the money. The man was furious. He told his lawyer, I paid the judge. This is preposterous. And because we are officers of court, we have access to chambers. We can walk into a judge's chambers and speak also what is in our heart. So the lawyer went and said, my lord, my client says you were paid, but you, having received the money, you never did your part. So the judge said, who brought me the money? Your clerk. Call the clerk. The clerk came. If Africans could blush, the clerk would have blushed. So there are those cases. So standing here as the Minister of Justice, I hope, my Lord, this consoles you. Generally, people trust the judiciary. But just like bad news travels faster than anything, now Ugandans have developed inbuilt biases. Let's work together to overcome these biases. This also happens in our ministry. We are always accused of selling cases, that we are going to lose a case deliberately by collusion. But I believe the Attorney General is tackling that with all the vigor necessary. I am convinced that, and I'm closing before I invite the Chief Justice, our chief guest, we need 360 degrees justice. Recently, I was accused in Parliament of keeping so-called criminal lunatics, people with mental illness, in jail. Well, as you know, I've only been Minister of Justice for a few months. But, you inherit all the sins. So, I want to state clearly here that working with our team in the Ministry of Justice, we have issued the so-called ministerial orders. And all those, now, ministerial orders does not give me the powers of court. Some people misthink that I thereby have the power of court. That doesn't make me a judge to adjudicate a case. But I can do things. When the doctors tell me that this criminal lunatic, for lack of a better word, is now capable of standing trial, I send them back to court to stand trial. 2, when the doctors in the prisons tell me that they are sick, I issue an order to remove them from prison and take them for treatment. That is what is humane. I apologize on behalf of the ministry for the delay. To be honest, some people have spent over 10 years waiting for ministerial orders. We had to work very hard. The Attorney General and myself went and met the principal judge, and they have compiled all the cases, and we have disposed of all of them. There is no ministerial order pending. Of course, I also play a role in the exercise of the prerogative of mercy by the President. So we are doing our best and working with the prison authorities. We hope to advise the President to exercise that clemency as part of the celebrations of our 60th independence anniversary. And I'm sure the prison authorities will be very happy, because there are some people who you see that really they have benefited by spending time in those facilities. And there is really no real need to keep them confined anymore. They can go back into society. But since they are convicted by court, the President can now exercise that prerogative and have them freed. That is something we will also do. We believe that is our duty to advocate for additional resources for the police to investigate cases. Your Excellency, you talked about speedy trial. Sometimes gathering evidence is hard. You can imagine those terrorists who were arrested and the evidence had to be gathered from Afghanistan in a war zone. You are then conflicted. Here we have porous borders. Some of our evidence is in Congo, some of it is in neighboring countries, and the police does not have money. Police officers are struggling. So, my Lord the Chief Justice and his judges are waiting for us. The DPP, on account of a little salary enhancement these days, though the numbers are still very few, they don't have enough staff. They will also be waiting to go to court, and they are calling the police, bring the evidence. So that's why I talked of justice 360 degrees.
we are currently urging the government not only to build the muscles of the judiciary and the DPP, and then the justice system has very thin legs in the police. That's not a very attractive person with the strong muscles in the arms and a big chest, but the limbs are really... Because the justice system stands on the investigative capacity of the police and the capacity of the prisons to bring the suspects to jail. So let's deal with those thin legs. The thin legs of justice are known because now the judiciary is fairly muscular. We are recruiting more judges, more magistrates, and so on. But the thin legs of the police, the thin legs of the prisons, the prosecution, that is what will guarantee access to justice. So the rest are symptoms of those thin legs. The long remand, those are symptoms of the thin legs. So deal with the anemia, lack of oxygen, kwashako. As far as I'm concerned, that is really what I wanted to get off my chest. My people there wrote a nice speech for me about NDP3 and so on. I'm not going to inflict this speech on you. It is not necessary. I'm grateful that you have all responded so that we can be effective as part of the solar system. We thank God that we have a forward-looking Attorney General who leads by example. We also thank God that we have got a Chief Justice who is defending very militantly the independence of the judiciary. You have to, first of all, knock him down before you go after any of his officers. He's standing in the door, and he's not afraid of anyone. We salute you, my Lord. Let's go and work. Let's go and work. The organizers, those who have funded this, thank you very much. They always say government functions are not well organized. This is fantastic. You know, you have set up something. We are now competing with the NGOs. You know, we have multimedia. When I was coming here, I was actually virtually attending this function, listening to the music. Some of the songs you were playing are songs I heard as a child. They are songs from my part of the country. Thank you very much. Let's go and work. My Lord, it's now my singular honor, on behalf of all of us participants, to invite you to address us, my Lord, the Chief Justice.
Thank you, Honorable Minister, for recognizing that I fight for the judiciary. Actually, I do not fight for the judiciary, I fight for the Constitution. Honorable ministers here present today, the learned Attorney General, my lords, justices and judges of the courts of judicature, Your Excellency, the Chairperson, JLO's Development Partners Group, Your Excellencies, heads of diplomatic missions, the distinguished members of the JLO's Leadership Committee, the permanent secretaries of various ministries, the heads of constitutional bodies and commission, And on this, let me recognize one person who was named and not seen him and not recognized he was in. This person is one of the poorly recognized elder of this country. He has many accolades to his person. When I was a law student in the early 80s, one of the judges of the High Court whose judgments we raked for everywhere was his. Then when we were active in student politics at Makerere University, he was a Right Honorable Speaker of Parliament. And I think he finished his high service to this country as an ambassador. I'm referring to Right Honorable Speaker, Justice Ambassador Francis Butagira. I'm glad to see you. We always talk about militant chief justices, but we don't speak about suave and subtle minds that we have in our midst. Maybe we should begin using them in the type of conversation the Honorable Minister of Justice was talking about. and deploy less of the militant Ugandans full of blood and bile. Heads of constitutional bodies and commissions, members of the JLO steering and technical committees, distinguished ladies and gentlemen. I was ill-advised. I don't know whether I should apologize. I was ill-advised that would be required here at 10 o'clock. I didn't know, Learned Attorney General, that this August gathering would have to wait until I was present. I would have come here at 9. But for the sake of peace, let me also apologize. The Honorable Minister says in my culture, when you are late or when you are wrong, you shyly sneak in. I didn't see any shyness on his face. He walked with pomp and majesty. It is my pleasure to address you, the distinguished invited stakeholders of the Ugandan justice service system, at this 27th Joint Government of Uganda Development Partners, JLO's annual review meeting. This is yet an opportune moment to reflect and take stock of our achievements as the former JLO's institutions, against our set undertakings, examine our strengths and weaknesses, and move fast to seize the available opportunities in this call of duty, all geared towards making Uganda's justice system register a deeper positive impact in the lives of our people. Excuse me. Over the years, we have registered a number of milestones that have brought us to where we are now. I see a great opportunity in the current political and technical leadership of the justice institutions and a wealth of more experienced technical staff. Our cordial relationships with JLO's development partners, founded on a common conviction of justice for all, is an asset that has never let us down. We have also seen significant growth in our appreciation and awareness of the rule of law and the role of our institutions in administering justice and fostering an orderly society. The impact of our long-term investments can be seen in this most recent performance report, the one for which we are gathered here, and indeed reflect a sustained and systematic process of reforms and innovations. I would like to now highlight some of the high-level benchmarks that could paint the picture and show the direction of how far we've moved in achieving the goal of justice for all under the JLO's umbrella. At a macro level, public trust in our justice system is currently at 69%. This is a feat, of course, up from 59% in the financial year 2017-18. In a similar spirit, public satisfaction with justice services has grown to 64.4%, up from 59% in financial year 2017-18. Public trust and satisfaction are assessment parameters of the citizens' experience and indeed serves as feedback on the performance of our justice system. As a result of this collective approach, our performance is good so far. Nonetheless, we must push ourselves to aspire and achieve higher ratings. Further, I am proud to note that there is consistently an increased presence of one-stop point frontline justice services physically established in 74% of the districts across the country, up from 51.2 in 2016-2017 financial year. Our efforts in crime prevention and management have registered a positive trajectory with a consistent drop in recorded crime rates. On a year-to-year basis, we have dropped from 502 per 100,000 people at the beginning of the year under review to 457 per every 100,000 people, with a much lower reoffending or recidivism rate of 14.3%. The absence of law and order can quickly pave way for anarchy and quickly dampen economic development and prosperity for the people of Uganda. Comparable cases where insecurity reigns amidst a total breakdown of the rule of law are evident all over the world for everyone to see. The disposal of cases before the courts of law registered a tremendous increase over the one-year period under review, with a disposal rate of 55%, that is 205,967 cases, completed out of a total caseload of 373,974,000, a performance greater than the 49% disposal rate in financial year 2020-21, which was 157,875,000 cases. The effective and increased performance of the courts of law in the disposal of cases has a direct bearing on addressing several challenges, such as a reduction of case backlog and reduction of prisons, pretrial remand population that largely accounts for prison congestion. Lastly, I must echo the visible improvement of the justice infrastructure across the country. The construction of the Supreme Court and the Court of Appeal buildings has reached 90% completion, and the JLO's house construction, launched on 10th of June 2022, is now at 24%, with the first phase expected to be completed in 2024. Besides providing decent working spaces for the justice actors, the efforts shall afford efficiency and saving in terms of rent of Uganda 9.6 billion shillings per annum for the judiciary appellate courts and US dollars 12 million for the jailer's house. These achievements and performance are a result of our collective action as justice institutions with complementary support from our development partners, undertaking process reforms, human resource capacitation, automation of some of our processes, and enhanced availability of legal aid support to the court users. However, despite some of these major achievements, there are challenges that have persisted over the years. On this occasion, I would like to mention only 4 for our consumption. 1, case backlog in courts of law is still a challenge that currently stands at 30.11%, that's 50,592 cases. As you may recall, in March 2010, the jailers, as it then was, launched its first case backlog reduction quick win program under the leadership of the judiciary. At that time, the case backlog stood at 24%. However, the current rate of 30.11% is something we need to pay close attention to. Nonetheless, I am optimistic that in leveraging the current political and technical leadership and development partnership in the justice chain, we shall soon overcome the challenge. 2, the second major challenge in the prison is the prison congestion levels that have progressively increased despite the noted faster case disposal and preference for alternative forms of punishment away from the traditional incarceration for especially minor offenses. This is a serious concern that urgently calls for our working together towards finding a solution. 3, the perennial problem of corruption, the one the Honorable Minister was talking about, continues to hover around the justice delivery system. I have noted that there are traits of actual corruption engineered by our own staff and the bush lawyers roaming around our offices. The other one is perception, the poor understanding of how the judiciary works, and what is called corruption is actually not corruption, but inadequacy, which is heaped on us by the people who have the capacity to make us perform better. We need to work together and ensure that we reduce the opportunities for corruption while mercilessly dealing with any culprits. Let me say this, explain this further. One of, actually the core agenda in my administration for the period of my tenure in the Office of Chief Justice is achieving access to justice. A huge chunk of corrupt practices arise from our inability to avail our people access to justice. That renders them desperate. A land dispute, and that's the only land the parties are dependent on, takes 5-7 years in a court of law. The nearest court of law, and I always say this, I use myself, the nearest high court from my village where I was born and raised is 160 kilometers. With no meaningful transport, you have to make a detour and to reach. As a matter of fact, because of the problem of transportation, it's more than 160. If I have a dispute with a neighbor, I am greedy, Shylock of sorts. And we're fighting over, in my place they don't fight over decimals. We fight over 10 acres, 20 acres. If you have bad manners and you want to take my 1 acre, I say something is wrong with you, go with it anyway. So we don't fight for these decimals I see you fighting for here. Now, my poor peasant neighbor has no capacity to take his 3 witnesses, 160 kilometers. I do. And cases are won primarily on evidence. What does this mean? The rich access justice, the poor are denied access to justice. And that explains why part of our agenda for access to justice is to litter the countryside with courts of law. So that ultimately, for the lowest court, a magistrate grade 1's court, everyone seeking justice should be able to walk, and I really mean walk, to court. Then there is parity of arms. The rich man can drive to court, the poor one can walk with his witnesses to court. Then there is parity. That's what we call access. But this is not all. The more important form of access to justice is that the judicial officers who man this infrastructure which we seek to avail our people must act in accordance with their oath. They must be ethical, they must be serious, they must be committed, they must understand the law, they must be availed the tools by which they can speedily dispose of cases that come before them. We are in the 4th industrial revolution. We must make all our judicial officers run alongside this revolution, be part of this revolution. Then we will eradicate corruption. Then it will, with a strong oversight function, inspectorate at every level, it will be a little difficult for those bad apples who spoil the name of the judiciary to find a window to practice corruption. So when we achieve this, then we have availed our people. We have availed the justice seekers through access to justice. Then corruption will be one of those things we read in books about fairy tales. It is possible. So the perennial problem of corruption continues to hover around the justice delivery system. I've noted that there are traits of actual corruption engineered by our own staff and Bush lawyers, as I've said. But as I said, we need to work together to deal with it. And let us be honest when we're talking about corruption. The judiciary, the police. I have said before, you know, when I don't know if a representative of the IGG is here. I don't know whether my good friend, the Inspector General of Government is here, or some representative. The most corrupt institution is the police, followed by the judiciary. So I asked the question, why do you say police is corrupt? Traffic police are always collecting money from people. 5,000 shillings, 2,000 shillings, at times it is 1,000. How about the permanent secretaries, the commissioners, the accountants, who by the stroke of a pen, just in one stroke of a pen in a day, steal money that can run Mukono district for 1 year? And you have the audacity to look elsewhere and say the judiciary is corrupt because some clerk takes 20,000, that, okay, I can make your file come forward, 20,000. That is not corruption, that is stupidity. The real corruption lies elsewhere. You can't say cough is more serious than cancer. I can cough every day for 366 days. It is an irritant. But cancer, no. Anyway, but we can have that conversation another time. Then, number 4, I'm aware of the imbalance in human resource allocation among the justice chain institution. The director of public prosecution, Lady Justice Jane, is she here? Yes. I'm seeing my sister there. She knows how I have fought for improved terms for the Directorate of Public Prosecution. I have put the case to the president himself, both in public, new law here, like I'm going to have in a month's time, judges' conference, and when we meet privately. I say, why do you give me a brand new vehicle to take me to Moroto, and you give me 30 liters? I'll stop in Iganga. So what is the purpose? Until we strengthen the Directorate of Public Prosecution and the criminal investigation arm of the Ugandan police, and then the courts to be able to preside over cases, there will always be delays of cases for which much of it, the judiciary is wrongfully blamed. Because the case is in court, it is not moving, the judiciary is blamed. When it is the state which is not doing its part. So we need to refocus. We need to strengthen these arms of government, the law enforcement arm of government, the prosecutory arm of government. There's no reason why a criminal case should be there for 2 years, it is not heard. 3 years, it is not heard. With better focus, you can actually have the case heard within 6 months. And as I told the president, if this were possible, this much debate about bail and what have you would be history. If I know you're going to be tried in the next 4 months, why should I grant you bail? Unless it is really exceptional circumstance. So people in charge of budgeting, please, you want the jealous fraternity to deliver. And I've said this about the judiciary. Many times people think the judiciary is a consumer institution. Far from it. We now have in the region of 7 trillion Uganda shillings in the commercial court division alone in Kampala. I'm not talking about the whole country. We're just locked up there. Because we are not bold enough to recruit 25 judges of the High Court per year. We recruit 10, and then the Chief Justice is supposed to send one to Kitgum, send one to Liamtonde, and and money is just locked. Money that could have meaningful impact on our economy is locked up. Take the land disputes. Land as an economic factor. The judge or the magistrate will give an order of injunction so that people don't cut themselves with machetes. And for 7 years, 8 years, even if it is 3 years, the land is locked up. Nobody is using it. It's lying fallow. We must do something and unlock this economic potential for the benefit of the country, so that the Honorable Minister of Justice does not blame COVID for money not coming in as it should have been. But we can do this, and these are the type of conversation we need to indulge in. What are our priorities? For how long shall we have certain areas being priority, and for us will be footnotes? When will we come to the fore also? These are questions we should be asking. These are questions we'll be willing to engage in. So that our people realize that justice is not a favor, or access to justice is not a favor. It is a right which they don't even have to plead for. Let me say something else before I close. A matter which is very important. Before now, the mode of planning in this country was sector approach in planning. For a year now, I think, the government of Uganda has made a paradigm shift from sector approach planning to program approach, what they call programmatic. At times you hear the word problematic instead of programmatic. So I think it is safer to say program. But it looks like the program approach is now becoming really problematic on things that need not even bother us, things that are clear like daylight, things for which one does not need additional lens. I'll just read an extract from this report. For those who have, go to page 133. There's a subheading, the second paragraph, if you have it, managing the transition from sector to program-based planning. I'll read it out in extension. The third National Development Plan, NDP3, is premised on the program approach to planning, budgeting, implementation and performance reporting, and JLOS is now a sub-program under the Governance and Security Program. The Governance and Security Program brings together 32 government agencies responsible for upholding the rule of law, ensuring security, maintaining law and order, public policy governance, administration of justice, promoting human rights, accountability and transparency. This program contributes to the NDP3 Objective 5, which is to strengthen the role of the state in development. The program goal is to improve adherence to the rule of law and capacity to contain prevailing and emerging security threats. Then it continues. Let me be categoric and unequivocal. Whoever wrote this got this from, it is partly and substantially incorrect. The administration of justice is not a function under governance and security. It is not. The administration of justice as a program is under the judiciary. It's a function of the judiciary. And we went to great length to correct this anomaly. Initially, the judiciary, parliament were all lumped under this program of governance and security. I objected and I said, never under my watch. Because then I would be abusing the Constitution, which, and for very good reason, and it is not peculiar to Uganda, it's very clear about the independence of the three arms or branches of government. It is very dangerous to subordinate the judiciary and make it play a fringe role under another program, which belongs to the executive arm of government. So I do not understand how access to justice, by whatever name you call can call it a sub-program, you can call it a committee, or what can be under security and governance, and then the Chief Justice of Uganda is on a program which focuses on access to justice. So we have parallel programs, one rightfully being done by the judiciary and another one under governance and security, where, as you can see today, except for the Chief Justice, the judiciary, the Chief Justice who has been invited as a guest, the judiciary is playing a fringe role in access to justice. This is ridiculous, this is dangerous, and must not be allowed to stand. If we accept that we are being governed under a constitutional dispensation, let us respect our boundaries. That anything to do with access to justice must be located, must be housed in the judiciary. And that's why we created the Administration of Justice program. Anything to the contrary is dangerous. It serves no purpose, it is meaningless, it is unacceptable. We went to great lengths and extricated ourselves out of the main door. Why should it be taken that the Chief Justice sits under a security program to discuss matters of the judiciary, and we are taken there through the window? That I will not accept. For as long as I'm Chief Justice of Uganda, I will not accept, and nobody in the judiciary will participate in a judiciary program which is housed in the executive arm of governance. We need to be very clear about this, and it must stop. We can't be debating the same thing all over again. For whatever the reason is, that I will not accept. Otherwise, I would like to extend my gratitude to His Excellency the President of the Republic of Uganda for the continued government support to the justice institutions. As I said, because of our conversation with His Excellency, who has adorned our function with his presence for a long time, the judicial budget was leapfrogged and doubled, and we have been able to do a number of things in the pursuit of ensuring that our people enjoy access to justice. We really thank him, because the moment he saw it, he implemented. True, we would have been way ahead, but for COVID. And I hear some other things which are not related to COVID, but I don't normally like to participate in rumor mongering. I also, in a special way, pay tribute to our development partners. Your Excellency, I addressed you on this on behalf of your colleagues, our other development partners, for the financial and technical support rendered to us, without which we would not have reached this far. When you see this report of what we have done, it is principally because of the commitment, the dedication, and the love our development partners, or the love of their taxpayers through their representative here, have done for this country. To the heads of institutions and all of you gathered here today in your respective capacities, I implore you to continue to steer the course of justice. After 25 years, we must turn a new page of continued justice reforms, innovations, and development as we aspire for justice for all our people. Gratitude is also extended to the civil society organizations such as the Legal Aid Service Providers Network, various international organizations such as the Hague Institution of International Law, HIL, and the members of the academia who have also been instrumental in complementing the justice reform processes, especially in the areas of legal aid. To our technical staff and teams involved involved in the daily justice delivery pursuits, we celebrate and appreciate your work. I would like to especially here today thank and commend the technical team of the former jailers, Mrs. Rachel Odoi Musaga. Rachel, where are you? Please stand up for, yes. And Mr. Sam Wairagala. Where is Sam? When we talk of this report, when we talk about accomplishments, these two persons and the team that have led in the Secretariat have made it possible. They are committed Ugandans, people who love their country. And I thought, on an occasion like this, I must give special recognition to them. We hope you are not bolting. We hope wherever the Secretariat for Access to Justice, whether it is a sub-program or whatever it is, you'll be available to serve your country. As I've said here, you did a wonderful job in coordinating us under the chain link, and we heartily thank you for your spirited energy and industry, as well as the commitment I'm talking about. We now look forward to a new collaboration that takes cognizance of the independence of the judiciary and the judiciary position as a leading institution in the justice service in the country. What am I saying? I think the PS or Minister of Justice said it, but I would paraphrase. I wish I'd captured the statement. You cannot sever the code that links access to justice and the judiciary and the administration of justice. Access to justice is just a component, a subset of administration of justice. So this is really what I'm saying here. With these remarks, I would like to officially declare the 27th Joint Jailers Government of Uganda Development Partners Annual Review officially opened. Thank you.
Thank you very much, my Lord. I request that we all put our hands together in the strongest terms for the most realistic speech of the day. Next on our program is to launch the report. My Lord, I request that the team that is on the high table crosses to the next high table. In a special way, this is going to be a symbolic launch of the report. And of course, after the report, we shall have the group photo and then tea, and then we come and do the real discussions of the report. So the team, I request that we move. Being joined, we know the development partners and the access to justice teams make an effort to make one report. And as you can see, do I have to count? I think I may have to count from 3 to 1. 3, 2, 1. The rest of us who are not going there, I request that we put our hands together for the launch that is going on. Can we clap, please? Because that is our document. That is what we have all been doing. Okay. 3, 2, 1, and 0. And we're making some signatures there to confirm our action. I can see my Lord the Chief Justice holding the dummy of the report. I think it would be prudent that the head of the development partners also touches the other end of the report for joint ownership of our report. Yeah, thank you. Thank you very much. I think, photographers, are you done? My Lord, I think let's continue and take the group photo, and we have the leadership team, the leadership committee, and the steering committee joining the team on the photograph ground. Members of the leadership committee and steering committee, let's join the team already for photographs, and let's do it fast. Yeah, leaders, the heads of access to justice institutions, you know you are leaders of and the steering committee, yes. The band, we can be having some small music, but very low. Because of space, I am going to request that we shall be taking batch by batch. As the leadership and steering the steering committee can come back, then the next. Here we shall be taking at random. This column we go, then the next until we complete. So let's try to be fast. Bwana Nanga, you lead your team. We are taking this group to have the group photo. As those who have finished taking the group photo, I think it's time for tea. Let's have tea in order to manage time. Ushers, guide our team for tea. The second group, I request we be joining in as the other ones are going through. The Secretariat should be following this group because they have played a very big role. We expect the Secretariat to feature prominently in what is going on. I think the rest of the group can go at the same time. This space is enough. The rest of the team, I request that we all come and have a group photo. I see the space is enough. Let's all come and feature in our group photo. And like I said, those who conclude the photography, let's continue for break tea. The tea is behind the prison's band. Law reform. We recognize the president of the Law Society. We recognize the chairperson, Tax Appeals Tribunal. We recognize the advisor to the judiciary. And of course, we recognize the public relations officers for different agencies: police, judiciary, Ministry of Justice, prisons, Ministry of Internal Affairs, to mention but a few. Sir, I request that you take your seat up, and then the members to invite right on the program to come and join you, sir. The chair of the session has requested me to invite his team, and the members of his team are the Solicitor General. Solicitor General, sir, you are requested to take the seat next to the chair. And the second member is Chairperson, Access to Justice Development Partners Group. Those are the two members with the chair.
Distinguished participants, invited guests, ladies and gentlemen, good afternoon. I take this honor to invite you to welcome you to this session, the second session. I welcome members of the team for this second session. The second session, we are receiving the Access to Justice annual Performance Report 2021-2022, which will be presented by the Solicitor General and the Secretariat. Thereafter, we shall receive response from the chairperson, Access to Justice Development Partners Group. So you are welcome to this session. I want to take this honor to invite the Solicitor General to introduce the team and introduce the report. Solicitor General, please.
Thank you very much, Chair of this session. My lords, justices and judges of the courts of judicature, Your Excellency or his representative, the head of the EU delegation in Uganda, and chairperson of the JELOS Development Partners Group, Your Excellencies, heads of diplomatic missions in Uganda, heads of JELOS institutions, members of the JELOS steering and technical committees, distinguished invited guests in your respective capacities, our audience online, ladies and gentlemen, good afternoon. My name is Francis A2J, Solicitor General and Chair of the Access to Justice Steering Committee. I'll give a brief overview of the report, and then I'll request the technical people to come and give an in-depth analysis of the report. The Access to Justice Subprogram presents its annual performance report for the financial year 2021-2022, the first performance report under the program-based approach. This Access to Justice Subprogram Annual Report 2021-22 provides information on the performance of the subprogram for that financial year. The objective of the report is to highlight performance made against set targets and actions. This report is supplementary to the government annual performance report produced by the Office of the Prime Minister. The outputs, their indicators, and associated targets and actions outlined in the financial year 2021-22 sub-program work plan and budget are used as the framework for the analysis. The performance information in the report is generated from the analysis of the data from institutional submissions. This strategic report tracks progress and results information in the outcome areas of the access to justice / JELOS business to enable the sub-program and development partners, as well as other key stakeholders to assess progress and target areas for reorganization or increased investment. The progress report is about the totality of the JELOS resource envelope, which includes the swap basket funds, Government of Uganda recurrent and development expenditures, as well as other multilateral and bilateral project support that the sub-program institutions access during the period under review. The report follows the Access to Justice strategic plan structure and tracks progress against targets set in the financial year 2021-2022 work plan and the monitoring and evaluation framework. I wish to reiterate that the sub-program performance is a collaborative effort and is delivered by the synergy that is provided by the sub-program management structures at both national and subnational levels. We applaud the members of the JELOS Leadership Committee. I also thank colleagues and members of the JELOS Steering Committee for the policy direction to the sub-program. I wish to also thank the foot soldiers and the technical committee and other working groups and the subnational committees for the dedication that has enabled us to register improved performance. We also applaud the JLOS development partners who continue to support the sector even as we transition to the programmatic approach. The following deserve special mention for their contribution to the sub-program: the European Union budget support and project support. We thank you so much. The Netherlands earmark program support, Austria budget support, UNICEF for support towards implementation of the Justice for Children project. We thank you. We thank UNFPA support towards the SGBV special sessions. This is what the ambassador was talking about this morning. We thank the UNDP rule of law and constitutional democracy, as well as the peace, security, and system resilience programs. We thank Sweden IDLO budget support. And last but not least, we thank the UN Women Project support. The Honorable Chairperson, allow me now to invite the Secretariat to take us through the detailed report. I thank you for listening to me.
Thank you, Solicitor General. Secretariat, please.
Mr. Sam Wairagala.
Thank you, Chair. Thank you, the Solicitor General. Allow me, in the interest of time, adopt the protocol as ably laid down by the Solicitor General and the other speakers. My lords, ladies and gentlemen, this is a special day because it marks the true transition from sectors to the program approach. We can either make it a problem approach or a program approach. The choice is ours. But from the history that we have shared over the past 25 years, the institution is under the chain of justice. Always take the lead in adopting to change. Because change has come. We cannot fight it. What we all need to do is find a way to align ourselves to the change and make the best out of this change. Even initially, I believe for those who were there during the Mamba Point way back in 1999, many people never understood the sector-wide approach. And I'm sure they were asking those hard questions, how can I work with so and so? But we came to realize that 20 years later, we found it well appealing for us to work together as a team. Because the most important aspect in all this, even under the programmatic approach, is making sure that we talk to one another. Is making sure that we coordinate our processes and systems. And where possible, cooperate to be able to deliver the services. And I think those ones remain core, even under the new dispensation. This is the first such report under the program approach. And where we are having challenges of having that hangover from the sectors to the program approach, we should always believe that it's a learning experience and it's a learning process. I think what we need is to take the policy pronouncements that have been delivered today in this meeting, the foot soldiers. How do we translate these policy pronouncements from the ministers, from the Chief Justice, to something that delivers, to something that enables us to appreciate our shared vision, our shared values, and the way we have to move forward together as a team. Chair, my role is very simple. the head of the Jailhouse Development Partners Group and the Chief Justice have more or less presented the report. You have all got the figures and numbers. Mine is just to walk you through a few of the areas and just highlight. The report is about 200 pages, and we would need about 2 days to go through the whole report. So allow me to just take you through a summary. Over the years, even under the sector-wide approach, we focused on building the bridge with the people. All these other aspects that many people talk about, corruption and so on, affect one major issue: the trust, the confidence that the people have in these institutions. Of course, when people have no confidence and trust in an institution, they always invent their own way. They always find a way to serve themselves in their own way and in own style. And we have always heard things about mob justice. We have even witnessed it. It's because people are recreating their own form of justice when they do not believe in the formal ways of justice. But I want to present and reiterate the changes that have taken place, that now more Ugandans trust us. More Ugandans trust the institutions within the chain of justice. And of course, this comes with the overwhelming numbers, and sometimes may lead to reverse of the gains that we have made. As highlighted by the Chief Justice, more than 69% of Ugandans now trust the institutions of justice delivery. And that is a plus for us. All these other things we are doing, building courts, recruiting more prosecutors, recruiting more policemen, and so on, would not translate into anything if the institutions that we are targeting do not trust us. But we are now seeing the gains we are making with the various investments, that now progressively many more people trust our institutions. This is not statistics that we create. It is from an independent survey undertaken by Reeve Consult as part of our end-term review of the sector development plan under the sector-wide approach. We are also heavily invested in addressing the challenge of crime. Of course, with the media and other aspects, because of reports we receive and others, you may think the crime rate is growing. But from the reports, as earlier even presented by the Chief Justice, we've seen a corresponding reduction in levels of crime, partly attributed to our rehabilitation programs in prisons, and also the use of various modes of fighting crime, including adopting the use of community service, community policing, and other aspects within the area. The rehabilitation of prison inmates has enabled us to reduce the rate of reoffending from as high as 24% in 2016 to now 14.3%. One of the lowest rates of reoffending within the African continent, and maybe even the world. I noticed that when you go to places like South Africa, the rates of reoffending are 85%. In other words, the chances that somebody who has served in prison will always come back to prison is 85%. In Uganda, it's now 14%. It means that people who go into our system as inmates live as rehabilitated persons. Many of them have become farmers. Many of them have become owners of welding areas, carpentry workshops, which have enabled them to make meaningful change, not only to the communities that they live, but also to their families. Over time, those of you who have followed the story of the sector-wide approach and also of JAILOS, we have been moving from a period where we're merely stabilizing institutions to now when we are looking at how do we best serve the people. It's no longer about whether I have handicaps, whether I have uniforms, whether I have stationery to perform my function. We are now looking at how close are we to the people. And currently we have reduced the distance in which people traverse in search of jail services. And people now can access jail services within a 15-kilometer radius. Just go look at your area where you come from and measure the distance from court, from where you are. You will always see that distance is reducing by day. The distance is reducing by day for you to access a police station, for you to access DPP services, and we have been able to cover 74% of the districts in this country with construction of one-stop service points. But in terms of presence, physical presence, we have covered 117 districts out of the 140, and these are growing by day. Hopefully, with increased investment, we'll be able to catch up. But our target was always 117 in terms of physical presence and construction. We are also addressing other ills, other aspects that affect delivery of services and ensuring that people correspondingly come closer to our services. For so many of you who have been in the sector, if you go to many of the institutions, our interest is to look at not only how trusted we are, but whether people are satisfied with what they receive from institutions. We have set up special machines with support from SEMA, and these machines enable us to collect real-time data on customer satisfaction with our systems. And we would want to commend the Directorate of Citizenship and Immigration Control, which has the highest level of satisfaction of 79%. Several other institutions have higher levels of satisfaction, and what we have realized is that many people measure satisfaction by the amount of time they spend in accessing our services. The more time they spend seated waiting for a service, the more dissatisfied they are. So time is a critical factor. We need to be able to make sure that at the end of the day, we progressively ensure that people stay for less time when they come to our institutions in search of services. We are not saying that we should hurry them through, but if they are not responded to with time, their levels of satisfaction reduce. His Excellency, the head of the delegation, talked about the Jealous House, a game changer for the program and for the sector, a one-stop service point, and we are saying come 2024 June, we should be celebrating the first milestone of a completed twin tower to house some of the institutions that are renting today. This is work in progress. The quality is at the level of expectation. The speed is at the level of expectation. In terms of time, since its inception, since it's the start of the construction, 24% of the time elapsed and 23% of the construction done, and notwithstanding many of the challenges. So the contractor is on schedule, and this particular construction is going to provide 69,000 square meters of office space. And the Chief Justice talked about the savings that are going to accrue out of this. But the most important thing is that we shall reduce the time people people spend in looking for these services. You have to go to DPP, workers' house, then you cross over, you go to Naguru for policing services. Even in police, you are not going to get these services you are not getting these services in one place. You get them dispersed, some in Kololo, some in Kabaragara, others in other places. But this is going to enable us access these services within one place. And not only that, but they are built for purpose. We are moving our way from renting of shops, sometimes bars, to purpose-built offices, which take into consideration the chain and the service chain and the business process within these institutions. And so, together, we believe that we'll be able to realize this. We have talked about legal aid, and a lot has been talked about the bill, the private members bill. I will not, the minister said a lot about this. But the most important is that we are to implement the law. And we are experimenting on how we can have state-funded legal aid services with Justice Centers Uganda. Justice Centers Uganda is for the whole sub-program. It is not for an institution. It is, we initially, it came out of a fund that the donors had put up, the legal aid basket fund. And later on, we had the DGF, Democratic Governance Facility. But all these were supposed to play a complementary role. Our interest was, how do we learn? What lessons do we pick from this process? As a pilot, how do we move it forward? Currently, 45.1% of magisterial areas are accessing standard state-funded legal aid services, partly because of this particular Justice Centers Uganda. It means that more than 50% of the court system do not have access to this process. We also have a responsibility to ensure that the non-state actors who provide services, legal aid services, meet standards. Otherwise, people will come in their proposals indicating provision of legal aid services, yet in the actual sense, they are doing something else. So we as a sector and as a sub-program are focusing on ensuring that all the legal aid service providers meet the service standard, and this is a responsibility that is being played by Law Council. And we can report without fear of ever that now 85% of the legal aid service providers meet service standards because of the strengthened regulation of the service providers by the Law Council. In terms of juvenile justice, our responsibility is to ensure that we have child-friendly services across the chain and across the various institutions within the chain of justice, because children are delicate. And one of the areas we have invested in is diversion of juveniles. This has been done through adoption of guidelines and other processes and procedures, and building the capacity and conscientization of the various players within this chain. Of course, we now have a new Succession Amendment Act, and the issue is, how do we take this one forward, and how do people access the revised laws, the enactments, and be able to appreciate and implement the laws. In our fight against crime, we indicated that crime is progressively going down. This has been possible because of the adoption of scientific approaches. We now have the CCTV processes. We no longer, we have seen many such programs delivering results and delivering and supporting the investigation of crime. Many people now would look around when going to commit a crime, whether there is a camera nearby. We have now been able to cover the major cities and municipalities, and also on highways. Making use of the canine unit, we have been able to cover 79 police stations countrywide, and also making use of scientific evidence, forensics, and also other anti-crime infrastructure. We just want to inform members that we have now moved away from the magnifying glass when it comes to comparison of fingerprints. We now have the automated biometric identification system, which enables us to compare fingerprints within a very short time. And this is also being done together with the integrated ballistic information system, where we have been able to fingerprint all the firearms within the country. We are also engaging in community programs that have enabled us to not only improve performance, but also support us when we're doing investigations. The skilling of investigators and prosecutors, the improvement within the investigation arm, and others have enabled us to register very high conviction rates for the cases that go to court of up to over 70%. And we are also making use of alternatives to imprisonment to enable us reduce on exposure of first-time offenders to hardcore criminals. And in the reporting period, about 70% of the cases that were processed through the system and convictions obtained were the suspects and other convicts were sentenced to community service. In terms of transitional justice, one of the aspects that we bring out here is the absence of a witness protection law, which is critical in this area of transitional justice, aware of the nature of the cases that are being handled, and also taking cognizance of the need to protect these witnesses. We now adopt ad hoc witness protection measures. Otherwise, we would be having challenges in trying the cases of Koyero, Jamiru Mukulu, and others, which remain a big challenge, and they are very costly. And I think what we need to do is look at a project approach to dealing and disposing of these cases. We have a national transitional justice policy and efforts to ensure that it's disseminated and it's implemented with a clear legal regime ongoing. One of the institutions that have been critical in supporting the congestion of cases within the formal criminal system are the local council courts. Our focus here has been ensuring that we build their capacity. But I want to let you know that there are smaller things within the local council court system which have far-reaching implications. And one of them is as simple as a stamp. Previously, everybody had their own stamp. The chairman has a stamp, the secretary has a stamp, the former chairman has their stamp, and others. And so you have all these people with their stamps. But we want to report that though very simple and to some people very insignificant, the availing of customized stamps for LOCs has helped to avert a lot of other challenges that we are facing. There are people, for instance, who had become experts as sureties in court because they had their own stamp. So somebody wants to apply for bail. There is another team. There is a team laid out around in the court with their stamps ready to play their own tricks. And the availing of these stamps has been something that we have not taken for granted because such cases are beginning to reduce. In terms of disposal of cases, this has heavily been laid by the Chief Justice, and as well as other processes. We are looking at strengthening case management systems and ensuring that the institutions are able to deliver. And the strengthening of case management systems has enabled us to achieve a reduction and a reversal of the number of pretrial detainees that we have within the system. As I speak now, the number of pretrial detainees are less than those that are convicted. The gap was too wide at the start of this year because of COVID. And now the lines have crossed. We are now at the level we were in 2019 before COVID. And this is the way to go. But he has brought one challenge. We now have about 36,000 inmates who are convicted, out of about 70,000 inmates in the prison system. And so even if we said that let all the remands go home, we shall still have a problem of overcrowding, because the occupancy rate in prison is 355%. In other words, the prisons are carrying almost 4 times the approved carrying capacity, and something that we need to address. But ultimately, we are not having a violation of rights based on pretrial detainees. Now we have to deal with the problem of congestion within the system. We are, by and large, advancing technology, making use of e-systems, ProCamis, e-visa. Now, time we no longer have people who are experts at filling immigration forms, because you can always do this in the comfort of your home. You can also do the same in registering a business at URSB. We also have similar processes and programs that are ongoing in other institutions, and our aim now is to ensure that these systems are able to talk to each other and are able to transmit data across the chain of justice. We are also cognizant of the challenges we have with our legal regime and the need to address the complexities therein, and the report has details of the major areas of reform that we have been able to address and what else is remaining. In terms of strengthening capacity and decision making, we are looking at numbers, we are looking at skills, and we are also looking at processes across the chain of justice, and ensuring that we have the numbers of people to process the information, and we also have the requisite skills for those particular people whom we have recruited within the system. But we are still far from reaching the optimal numbers within the system. Compliance with the Bill of Rights. 19% of human rights recommendations implemented against a target of 30. 20% dispose of human rights cases against a target of 20. And one would ask, why targeting 20%? It's because at this point in time we had no commission. And the fact that now the commission is fully constituted, we can now take a breath and now work on improving these numbers. Conviction rates in the cases of corruption, 81%. Kudos to the team that is doing the investigation, the prosecutors, led by the DPP, the investigators across board, and then the adjudicators, led by Justice Gidud. We give them kudos for this performance. And now, for those who want to engage in corruption, you look at the conviction rates and then you think twice. We have continuously improving on the number of Ugandans aware of the Bill of Rights. And we are also ensuring that as part of the NDP3 programming, we are able to integrate human rights-based approach into the planning process. And we begin with the policymakers and the planners. Of course, we also look at the case system, the number of cases that have come in the system, and what it means for all of us, the aspects that we need to deal with, the challenges that remain at hand. I'm sure we all know we have always had these issues, torture, and all these. Just 2 statistics. When we compare 2 years, they are all election years, 2016 and 2017. 2016, 1,000 cases. 2017, 1,000 cases. 2018, 1,000 cases. 2019, 1,000 cases. 2020, 1,000 cases. 2021, 1,000 cases. 2022, 1,000 cases. 2023, 1,000 cases. 2024, 1,000 cases. 2025, 1,000 cases. 2026, 1,000 cases. 2027, 1,000 cases. 2028, 1,000 cases. 2029, 1,000 cases. 2030, 1,000 cases. 2031, 1,000 cases. 2032, 1,000 cases. 2033, 1,000 cases. 2034, 1,000 cases. 2035, 1,000 cases. 2036, 1,000 cases. 2037, 1,000 cases. 2038, 1,000 cases. 2039, 1,000 cases. 2040, 1,000 cases. 2041, 1,000 cases. 2042, 1,000 cases. 2043, 1,0 and 2021. When we compare the 2 years, in terms of cases of torture reported, we see a 45% reduction when we compare 2016 and 2021. I think here, somebody will say that we are comparing two pygmies, who is shorter and who is taller. But we are seeing movement in the right direction. Cases of denial of the right to liberty, 35.3% reduction when we compare the two financial years. We are also dealing with the challenges of sanitation within places of detention. We more or less addressed the prison system, and we are now looking at police stations, but some of them are operating from grassroots houses and people's shops. And as we continue to build the infrastructure for the districts and also for the counties, we believe that this will be meaningfully addressed. We are also integrating human rights-based approach human rights-based approach in policies, in legislation, in plans and programs, and we are also looking at ensuring that our staff are trained, that we also link up with security agencies who are always adjudged to be major violators of rights. In terms of prevention, detection and elimination of corruption, we talked about the conviction rate, but also beginning recovery. And in the reporting period, the DPP was able to recover 8.5 billion shillings from some of these cases. We also applaud the institutions for the high clearance rate of cases, which is much higher than the total number of cases that are registered within a period. And of course, the higher levels of conviction and the clearance rate of some of the cases within the Judicial Service Commission and other institutions. This wouldn't be possible because we need resources, we need money. Despite the COVID challenges, which resulted in a reduction in resource flows to the sector, we registered a 97.7 outturn in terms of the approved budget for the program institutions, with wage 650 billion as approved and 646 billion released. The non-wage 1.07 trillion and the release of 1.205 because of a supplementary to the institutions that were involved in the fight against COVID and the enforcement of the standard operating procedures. We would want to acknowledge the basket support, the fund. It's very little amount of money, but it is the glue that enables us to stick together as program institutions, without which everybody would be back in their own homes and struggling with their own small institutional challenges and issues. But because of this small glue, it keeps us together, and it is even the reason why we are here doing a review. It enables us to also examine ourselves with regard to the totality of the resource envelope. I just want to inform you that the overall program budget is 2.1 or 2.2 trillion when we incorporate the supplementaries that were received, compared to about 70 billion that is managed as the basket, and it enables us to direct the other 1.2 trillion shillings to deliver the results that we are able to deliver. Would want in a special way to applaud the government of Uganda together with Austria, because Austria provides budget support of 2 million euros, And that, together with the government contribution translated into 40.9 billion shillings, are released to the sector or to the program within the year from both government and Austria, which is the sector budget support donor. And I think Austria has been the longest supporting sector budget support donor. Even when there are challenges, they keep around. Even when there is that Bahat bill, they keep around. And so we want to thank you. Want to thank the European Union. We have had implementation of a budget support framework for the past 3 years. It expired in 2021. But we remain hopeful that they will come back in another big way with yet another support. But currently we are implementing another program targeting refugees. And within the reporting period, they released 10.6 billion shillings to the program for supporting this particular activity. From the Netherlands, one also of the longest serving development partners, we received 9.98 billion shillings as earmarked program support for the program. And we just want to also inform you that we have received a communication from the Netherlands that they are coming back in another bigger way starting this year. We also received 2.5 billion from Sweden under ADLO, also a budget support donor. The challenge was how to manage our programming with the Ministry of Finance. Otherwise, they signed more than 25 billion shilling budget support arrangement with the government. And the faster we are able to work with them and unlock this potential, the better we have for us. So we big thank you to Sweden through the International Development Law Organization. The UN agencies, UNFPA, with the sex and gender-based violence special sessions, have enabled us even to reduce the number of cases within the system. We have been able to test the efficacy of faster trials and their impact on conviction. For some of these cases, sex and gender-based violence cases, the faster you handle them, the greater the outputs. Actually, we are now recording 80–90% conviction rates in the sessions because we are able to track the witnesses. The witnesses have not yet turned into married or people's wives, and so they can freely testify in court. It is very difficult if somebody who was raped 15 years ago and you are calling him or her now to give evidence. Nobody would want to be associated with such a matter. And so we would want to thank UNFPA for supporting us with up to 3.9 billion shillings, which has enabled us to address this particular challenge, and also enable us to test special procedures for sex and gender-based violence cases. For UNICEF, equals children and equals children's rights within the system. They have kept with us, enabled us to develop a conscious mind when dealing with children cases. And not only conscious mind when dealing with children cases, but also to be friendly. We now have virtual systems and processes. We now have fast-track processes. And the matters of children have now found space within the agenda of the agencies that are involved in the fight for the rights of children. And so thank you so much, UNICEF, for the support to the Justice for Children program. Of course, the Chief Justice talked about many of the challenges that we face. Backlog remains an issue, And so delays, nobody wants a delay. I've seen challenges even in hospital. When you tell Ugandans to line up for a service, they will be asking, is there a way I can jump the queue? So nobody wants to delay. So we need to address the issue of delay. A delay everywhere. But most important is certainty. I think now some of the institutions are beginning to see the fruits that are rising out of ensuring that if people are certain, you tell me your passport is going to be ready in 2 days, and sincerely in 2 days I get it, I will not ask questions. Even when you tell me to take 3 months, it's okay, I will wait for 3 months. But if one gets it in 3 months, another one gets it in half an hour, then they will assume that big cancer of corruption. And so together we need to work to expedite processes, because Ugandans want quicker and faster processes. We need to address the challenge of congestion in prisons. It's a time bomb. Prisons has a double-edged sword. The warder to prison ratio is 1 to 7. The international average is 1 to 3. In some countries, you have 3 warders for 1 inmate. For us, it is one warder for 7. And not only that, you also have a challenge of congestion. We may not deal with this problem only through fast-tracking the disposal of matters and cases. We also need to address the issue of infrastructure. We need to bite humble pie. We know that there are some development partners who say, for us, we don't touch prisons. Yeah, you may not touch prisons because in some countries they are closing them. But here we have not even reached the optimal level. We have not yet got there. For 47 million people, carrying capacity 20,000. And I want to inform you that Uganda in the region has got the lowest incarceration rate. Yes, our incarceration rate is less than 90 for every 100,000 people in the population. Compared to our neighbors in Rwanda, it's about 400. And you can see where the challenge is. So we need to address some of these. I not want to set the exam and mark it, Chair, but we can comfortably say that despite those challenges, the jail's access to justice program institutions have lived to the bidding and the target set, and we can comfortably say that the progress within and our performance is over and above satisfactory. That is the report. I thank you so much.
Thank you very much for a well-presented report.
Chair, just one small.
Please.
I normally don't stand here making a presentation alone. Rachel is always here, and I'm always on the lower podium. But unfortunately, she has not been well. But we want to give thanks to the Almighty God who has enabled her even to attend this review. I thank you so much.
Thank you. Thank you, Rachel. I now take the honor to invite the response from our development partners. Thank you.
Honorable Minister of Justice and Constitutional Affairs, Solicitor General, Director of Public Prosecution, Chairpersons of Constitutional Commissions, Permanent Secretaries, Representative of the Inspector General of Police, Commissioner General of Prisons, the team from the Secretariat of the Access to Justice, representative of development partners, of civil society, ladies and gentlemen. It's my honor to deliver these assessments on behalf of the Access to Justice development partner groups. I would like to thank the member of the group for the valuable contribution to the assessment. The methodology of our assessment has remained the same as in the past. Before providing a highlight of our assessment, I would like to provide some general comments. During the technical review on 25th November 2022, we had a constructive discussion and provided several recommendations to improve the reporting. Overall, we note that there is a marked improvement in the quality of reporting compared to previous years. For this, we would like to appreciate the valuable contributions of individuals and institutions who invested time and energy in the drafting of the report. I would also like to extend our appreciation to the Governance and Security Program Secretariat for coordinating the drafting of the report and for facilitating our cordial collaboration with the government. I now turn to the highlights of our assessment. I will start with outcome 1 on people-centered service delivery system strengthened. We know that public trust in access to justice institutions is 9% above the target of 60%, which is commendable. We observed the launch of construction of the Gelos House, which was already mentioned, which will be an emblematic building for the sub-program endeavors to create peaceful and well-functioning society. Although judiciary is not part of this sub-program, we would like to take this opportunity to recognize their efforts to improve the quality of state brief schemes to ensure that a person who cannot afford a private lawyer is represented effectively. We note that institutions have built capacity on management of gender-based violent cases, but a witness protection law would be crucial for more progress. We positively note also the UPF's responses to the high prevalence of domestic violence, including 7,000 sexual and gender-based violence investigations and training of trainers for handling of GBV cases and collecting evidence from crime scenes. The amendment of the Succession Act were eventually passed. With conviction rates now over 70%, the sub-program is making significant progress. We recall a time when it was just slightly above 50%. We observe that community service is important and shows good results. In the reporting period, the Ministry of Internal Affairs supervised almost 17,000 community service orders, which is a significant contribution to case backlog reduction, the community and rehabilitation of offenders. As it was said before, the Democratic Governance Facility, which has been supporting legal aid to more than 90,000 Ugandans, is closing. It's not clear how the sub-program will address this significant gap. It's also worrisome that prison congestion level increased from 323% to 351%. There is a need for reflection on the main reasons for the congestion and why the remand population keeps growing. We observe also with concern that the proportion of magisterial areas accessing state-funded legal aid is below 50%. Overall, the assessment of development partners of outcome 1 is satisfactory progress. I now turn to outcome 2. JLOS business processes reformed and strengthened. We note that the target for all 5 indicators were reported as met. These included case disposal rate of 55%, percentage of district with one-stop frontline services point at 74%, like it was said, and a conviction rate of 82% in corruption cases. We note with interest the conduct of normal sessions in the High Court. We heard that regular hearing of criminal cases was being piloted in the High Court, leading to significant reduction in backlog. This is an issue we previously advocated for, and we would please to hear more about. Other achievements reported include DPP consistently surpassing its quarterly targets of prosecutorial decisions. the country-wide rollout of small claims procedures, with a high number of disputes resolved at the pre-trial stage. A sizable number of cases were resolved through mediation with a success rate of 57%. Increased percentage of convicted prisoners from 46% to 49% during the period under review. Also, 200,006 cases, which accounted for 55% of the total caseload, were disposed during the period under review. With the highest disposal rate of 71%, we would like to commend the effort of lower courts in dispensing justice. In addition, we note further achievements, including the full adherence by UPS to production warrants, 171 cases won by the Attorney General, which saved 424 billion Ugandan shilling. DPP's sanctioning of 56% of land cases and prosecution of 75% of cases against a target of 70%. Furthermore, the target for level of automation of case management systems was exceeded, and the target of jailhouse institutions with a functional M&E system was also achieved. However, we are concerned about the 11 months average length of stay in remand. We are also concerned that female suspects spend about 4 months more time on remand than male suspects. Also concerning is the worsening of average time taken to dispose cases from approximately 870 days to 930 days. In addition, we note that budget cuts adversely affected operations of the DPP, and late releases further jeopardize their performance. UPF faced a similar funding challenge. It's also worrying that the monthly average prison population now stands at 70,000 inmates, a slight increase from the previous reporting period. Finally, we analyze that case disposal and clearance rates at the Supreme Court and Court of Appeal, and would like to encourage a reflection on how best to improve on the case disposal and clearance rates at these courts. Overall, the assessment of development partners on outcome 2 is satisfactory progress. I will now move to outcome 3 on compliance with the Ugandan Bill of Rights strengthened. We note the launch of the National Action Plan on Business and Human Rights in October 2021, which is a significant achievement. In addition, we note the inspection of about 590 detention facilities across 9 regional offices by Uganda Human Rights Commission. In future, inclusion of the methodology of these inspections and how involved other mandated actors, notably justices of peace, are in inspecting place of detention would enrich the reporting. We note the outstanding performance of the Anti-Corruption Court Division with a case clearance rate of 103%, a disposal rate of 51%, up from 48%, and a conviction rate of 88%. We note an interesting practice in the ACD which limits the number of mentions and adjournments to only 3, after which active prosecution must start to avoid dismissal of a case. This practice can be instrumental in addressing case backlog, lengthy trial processes, unnecessary arrests, or initiation of prosecution before investigations are complete. We note that, however, except the indicator on increased capacity of policy makers and planners on human rights-based approach, 5 out of the 6 performance indicators were not met. The indicators not achieved were proportion of human rights recommendation implemented, disposal rate of human rights cases, DPP's conviction rates of corruption cases, and proportion of citizens aware of the provisions of the Bill of Rights. Our view is that the finalization of the National Action Plan on Human Rights has stagnated over the last couple of years. Also of concern, the inspection by Human Rights Commission revealed inadequate staffing at most police facilities, coupled with a limited number of female police officers deployed at various police stations, and in particular in refugee housing districts. We note with regret the reporting of continued detention of suspects beyond the 48 hours as stipulated in the Constitution. This is an issue development partners have raised for several years, and we encourage the government to take action to address it. Also, regrettably, case clearance by Uganda Human Rights Commission was only 20% against a target of 76%, and the proportion of decision against jailhouse institutions to total cases concluded by the Ugandan Human Rights Commission is unlikely to have been achieved. Torture and denial of personal liberty remain the most reported human rights violations over the years, and the report states that the two most implicated institutions are UPF and UPDF. Another concern is the fact that the majority of 80% of trainees were men. The explanation provided in the report for this was not clear or convincing. There should be concerted effort to increase participation of women in trainings. Finally, we note the lack of progress in the development of a law to provide for recovery of the proceeds of crime. The overall assessment of development partners for outcome 3 was that limited progress was achieved. Therefore, in summary, 2 out of the 3 outcomes were assessed as satisfactory and 1 outcome assessed as limited progress. Thank you very much for your attention.
Thank you, Your Excellency, for the response. So the Solicitor General team and the development partners have all presented us the Access to Justice Annual Progress Report, which on the whole I want to say is pointing towards improvement. But they have also given us areas that we need to pay attention to do better. So I thank you for the reports. I thank you for giving us this, which you have assessed to be a very good report. Now, I think we shall have, members will have an opportunity to respond, but I think the response is the next session. So I want to take this opportunity to thank my members for this session. Thank you for the presentation, and I declare the session closed. Thank you very much. We are done. Thank you.
And in the interest of time, let me invite the chair of the last session for today, and that is the Director of Public Prosecution, to assemble her team, and we straight away go to plenary, and of course, then will be the closing, and we go for reception, and that would be it. Thank you very much. Let's welcome the chair for the last session.
Okay, thank you. Thank you so much, Master of Ceremonies and colleagues. I just want to join all of us to again once more thank the development partners for sticking around with us for this long. almost 25 years. The theme couldn't be better. Empowering people. What is empowering people? Empowering people is give them information. That's how you empower them, so that they know what to expect from us. Then building trust and upholding rights. We are going to take a very short time because I'm very aware of the time that we are sitting here with Dr. Sylvia. I want to introduce Dr. Sylvia Namubiru. She's the CEO of LapsNet. She's the one going to share with us. And please remember the Honorable Minister for Justice and Constitutional Affairs said you should steer clear of some words. So as you make your presentation, please stay in your lane. Dr. Sylvia, you're most welcome. I think so, it's better.
Thank you, my Lord, the chair of the session. I want to recognize all the protocol as previously laid, and I want to assure you, my Lord, that I'm very cautious of the language I use. Probably that's why I'm before this august house. I'm profoundly honored to have been invited to speak to this 27th Joint Government of Uganda Development Partners Access to Justice Annual Review meeting. It gives also pleasure and joy to share on behalf of the civil society sector our comments and perspectives on this report. We congratulate the Access to Justice program for coming up with a quite comprehensive Access to Justice annual performance report, which provides a strategic outlook and performance of the sub-program. I've been able to address my mind to the detailed report, and therefore we have given our assessment and perspectives in consideration of all the areas of the outcomes, but we shall stick to the most salient, especially that touches us from the side of civil society and the common person. Would like to appreciate the justice and order sector, specifically for the level of public trust that has increased to 69 and 70, which among us includes leading the time of delivery of services, opening up of service centers, ensuring certainty in service delivery, especially and also using online services. Would like to say that whereas the public trust remains high in the justice system as per the report, we would like to note that according to some of the justice beneficiaries or users that we have interacted with in several meetings, especially open days, in the year under report, Masindi, Kasese, Kitigum, there are still some bottlenecks that they continue to bring up, including the perceived corruption, the lengthy disposal of cases, and which puts a dent and undermines the confidence that has been built. But luckily enough, in those meetings, we always have representatives of the sector, and they are able to clarify. So we think that if we address and keep focusing on these bottlenecks, we shall go a long way to increase the trust. Crime rate reduction, this is very much welcome. And we've seen also that the sector is doing their best to handle crime, but not forgetting some of the increase of crime like theft, especially in this period. And this we pick from the police crime report. We want the sector to pay attention to the increasing crimes and reduce on their occurrences. We would also note, much as it's not within the reporting period, the increasing attacks on the law enforcement officers. As we've seen many police stations being attacked and leading to withdrawal of some of the police stations. This brings some fear, and we think that this directive raises concerns within the public sector, and we think that there should be more done to protect the law enforcement agencies than reducing on them. We need to see the police increasing its investment into the community policing as an effective model to responding to crime. We commend the judiciary and all the actors in the progress made, especially in the case reduction. This success rate could partially be attributed to the enactment, especially of the Judicial Administration Act, which significantly came in with an increment, of course, with the budget allocation. We'd like to urge the judiciary to continue with the recruitment to fill in the existing vacancies across all levels in a bid to strengthen efficiency and effectiveness in the administration of justice. In addition, we urge the judiciary to fast-track the introduction of the performance indicators, which will form a basis of appraisal as well as subsequent rewards and promotions. And review of other laws that need to be amended, like the Trial and Indictment Decree, the Magistrates Court Act, to increase on the jurisdiction of the magistrates, but also to deal with the committal proceedings at the level of the Magistrates Court. On construction of the justice centers, like the rest of the speakers have mentioned, we are very happy that the sub-program efforts are being towards construction of justice centers and decentralizing services. We are happy with the launch of the construction of the Justice House, and we hope that the construction will continue. We are happy with the Court of Appeal and Supreme Court, which are state-of-art buildings. We'd like to say that there is a challenge in selection of districts where such one-stop frontline points are established. Our concerns and findings that they are far-reach to reach districts like Amdat, Kitgum, and Omoro, where there are Omoro, where there are no court premises, despite the demand for legal services. We therefore request the Access to Justice program to prioritize extending to hard-to-reach areas. And we also think that the construction is a step in the right direction, but we should ensure that it comes along with efficiency and effectiveness in the service delivery, especially by the givers at all levels of the chain. The satisfaction at 70%, we commend it, especially as scored and analyzed by SEMA. This is the step in the right direction to assess the satisfaction and demand side. The rating of 70 notwithstanding, in our view, needs to be verified more. The samples used to determine the percentage score for various reasons, prominent among which include feedback we have continuously received from the public regarding satisfaction. This is not very well clarified, and we need to expound to know exactly some of the sources. The figures on the ground point to the continuous absenteeism of some of the judicial officers and state attorneys, corruption, especially within the justice givers, and also limited customer care. The common man's view, and we have appeared on several media platforms. Every time you stand, the questions that come, omwafta singa musango, loosely translated as a poor person cannot win a case. This is very, very evident as we continue to face it all the time. In our view, since we are still grappling with above challenges, the satisfaction rate in the justice services is equally still low than possibly what could have been reported. Of course, that is subject to verification. Access to the legal system strengthened through state briefs and also legal aid. We'd like to commend the sub-program towards promotion of access to legal aid services that is in line with fulfillment of the Constitution and other laws. However, we are all aware that the state brief scheme is still limited to criminal cases, leaving out the bulk of civil matters, which constitute the biggest percentage of cases. We have been complementing our civil society under the Legal Aid Service Providers Network to promote legal aid, but as I've already noted, the exit of the biggest legal aid basket fund, Democratic Governance Facility, gives a very huge gap. And this is exacerbated by the continued absence of the state-funded legal aid scheme. The legal aid policy remains at Cabinet 2012. Those are 10 years. The efforts of the promoters, Legal Aid Service Providers Network, and the private mover, of course, have faced a standstill. Honorable Minister, I thank you for bringing this out and giving a way forward of us appearing and giving more clarity to why we need the legal aid law. However, before we appear, I would like to shed some light. In 2017, a cost-benefit analysis was conducted on the legal aid policy in conjunction with the Justice and Order sector. And it gave the benefits of providing a state legal aid fund, socio-economic, political, and promoting access to justice. Further, it put the cost of implementing legal aid state-funded at 17 billion. And that is at the level of the justice centers, which is already a tested legal aid scheme. Meaning, currently, the amount of money would have increased slightly to operationalize the justice centers. We went ahead this year and received a certificate of financial implication, meaning the law was checked by the government of Uganda and the certificate was granted to the mover. The law intends mainly to sustain the existing legal aid schemes of government, such as the Law Development Center, to operationalize and regulate Justice Centers Uganda, and among others, put in place a fund, which fund can be contributed to by either development partners or government and or even other sources. And so the law was put to the level of the committee, and all stakeholders were invited to discuss this law, and the committee found it in their wisdom that it was ready to go back before the House. The Office of the Minister of Justice and Attorney General were also given the opportunity. Unfortunately, on the day when it was receiving the second reading and the third, that's when it was reverted back to the committee, of course, with concerns raised. Honourable Minister, whereas there would be discrepancies in this law, whereas there would be concerns of government, we believe that already the government of Uganda is already contributed to legal aid through the established framework, and the need to harmonize and have the law would be a right step in the right direction, within which government can slowly and gradually put more resources without necessarily doing it wholesomely. So I would like to call upon the government of Uganda through the ministry to harmonize, and we ensure that we move from this point because of the benefits of the legal aid law or the state-funded legal aid scheme. 88% of Ugandans cannot afford private practitioners, and we know that access to justice cannot be realized without lawyers. We are talking about strengthening the systems, strengthening the office of the DPP, strengthening the judiciary, strengthening the prisons, police. If we leave out the element of fair hearing or civil representation, we do not have achieved access to justice. And when we look at the benefits of peace and tranquility, then they cannot be measured to the fact that we don't have resources. So justice has never been cheap. And as we move towards creating centers and saving resources, I want to appeal to everyone here to look at legal aid as one of the benefits that can lead us into improved access to justice and a tranquility and a peaceful society. Today you can afford to go to court, but your grandmother in Kapira Maido may not when they are being evicted from the land, or your grandparent. So we need to clear this law and invest in it gradually, depending on the resources. I labored to stay there so much because it's a point that was raised and within the report, and from our perspective, we think, as civil society actors and legal aid service providers, we think that it has dragged over 12 years. It cannot be a justification to continue at this lane. A total of 78 legal aid service providers were supervised. We want to commend the subsector, especially through the Law Council, for the continued inspection and ensuring quality standards delivered through legal aid. Therefore, we invite the Uganda Law Council to reconsider reporting actual legal aid service providers, because when we say 78, the network has 58 in our documentation. It means 78, each office, branch office, is being counted as a LASP. So if FIDA has a number of branches, you count FIDA head office and another 10, the same with the justice centers, the same with the Uganda Law Society. So we want to appeal, especially in terms of subsidizing, that the inspection fees be calculated once for the institution that heads, and then others are also inspected, but also to contextualize the number of LASPs. Stakeholders empowerment and enhanced access to legal information. The skilling and empowerment of masses to know their rights, particularly how and where they can be accessed, has been greatly improved by the Access to Justice program. We thus commend the sub-program for enhancing legal empowerment programs. We see them through community outreaches, open days, TV talk shows, IES materials. This is the way to go, because a society that knows its right can ably protect. It is better to deal with prevention than dealing with prosecution or the aftermath. We would like to further commend justice institutions such as the Uganda Prison Service, Uganda Human Rights Commission, Uganda Police and Judicial Service Commission for always being available, especially for civil society engagements like the open days, where you clarify on the roles and mandates of the institution. The presence of such engagements is always welcome, and they are very instrumental in strengthening the public trust relationship. On outcome of the length of stay, that is the law and order business, overall on remand, we are equally agree that COVID has impacted us. However, our findings from the baseline study conducted under the pre-trial detention project implemented under ASF and funded by ADA, we find that there is a still overstay on remand, which is mainly propagated by violation of procedural rights of suspects. The 48-hour rule, the failure to grant bail, stringent conditions are veiled to suspects, failure of some judicial officers to release suspects when they clock mandatory bail, limited legal representation, limited legal knowledge, and the fact that we still have the High Court criminal session instead of having daily hearings. Therefore, in a bid to respond to these challenges, we propose that we fast-track definitely the enactment of the legal law, the application of the alternative dispute resolution, the alternatives to sentencing, and the observing of the procedural rights of suspects. Automation is greatly recommended. We are in the fourth industrial revolution, and we cannot go away from it. We thank all the institutions that have been able to automate their services. We want to recommend increased funding to the Uganda Police, the Uganda prisons, to also facilitate quickly their automation services and response mechanisms to investigation so that we can be on the same page. Alternative dispute resolution, we thank you for all those ADR mechanisms, pre-bargaining, ADR, and others. However, we note that court annex mediators oftentimes are not facilitated, and request that they are given more resources. We would like also to have the strengthening between the formal and informal justice systems. This would help to provide oversight, but also to create linkages and reduce on the overflow that comes to the justice systems. But also when they are supervised, they will have their practices having a human rights-based approach and also efficacy. But we know that the people believe in the Ubuntu and they believe in their traditional courts, and we need to facilitate them. Outcome 3, on the compliance with the Uganda Bill of Rights, I'm not going to dwell so much in all, but I want to speak to say we appreciate the efforts taken to reduce prison congestion. We also know that there are a number of incoming partners like UNDOC that is going to promote criminal justice. And also we know that there has been alternative punishments. In addition to that, the crime of rogue and vagabond has been outlawed, and we are happy that the Uganda Police has recently released a circular. We commend also the sub-program for having developed and launched the National Action Plan on Business and Human Rights. Our recommendation is to ensure that the effective implementation of this action plan will go a long way with strengthening state duty to protect human rights and enhance corporate social responsibility. The above notwithstanding, we still need financial support to complete the dissemination and mainstreaming of this action plan. The bringing in force of the Uganda Human Rights Commission is also very much welcome, and we know that the institution for the last 1 year has done a lot, including the launch of the 24th Annual Human Rights Report, convening legal and policy reviews, and other meetings that they've held. However, there is need for the Commission to toughen its approaches of responding to Human Rights Commission violations beyond the rhetoric statements, and thoroughly investigate and prosecute cases in an independent and accountable manner. Further, the Commission still has an uphill task of cleansing the human rights record of Uganda across globe. It has to boldly investigate and conclude cases of torture, abduction, and enforced disappearance, especially experienced prior to the 2021 elections. In a bid to increase the clearance rate of cases, which only stands at 20%, the Commission needs to be facilitated with sufficient resources, both technical and financial, especially to have the tribunal sit regularly. Lastly is the program management. The Access to Justice program acknowledges us for providing leadership and coordination role of civil society, especially in implementing the work of sector. We cannot take this for granted, and we are grateful. You have involved us in many of the ongoing policy formulation, like the anti-corruption strategy of the judiciary, the advisory council of the public in the judiciary, and we don't take that for granted. We thank you for always trusting the civil society to be part of your processes. Our request to the sub-program is to continue asking us and bring us back to the ladder so that the case statistics of legal aid service providers are reflected in the report, because they hugely contribute to delivery of justice through legal representation. On the whole, the performance of the Access to Justice program, in our view, is satisfactory, although more needs to be addressed in the areas where we have shared. We urge the sector to keep it up, especially where the performance is good. Once again, we appreciate you for inviting us to give our perspective and look forward to the year 2023-2022. Thank you.
Thank you so much, Dr. Sylvia. Please join me in thanking Dr. Sylvia for your comments. And thank you for you have always stayed in your lane anyway. You have always stayed in your lane, and that's why she has stuck with us all this time. Of course, the review is very important because it shows us where we are. It shows us also what we have done right and how we can continue with that, or what we have done wrong and how do we correct the wrongs. You have mentioned a number of things, and I don't want to repeat that really. You have mentioned a number of things, but I think pertinent is that we are all in the business of justice, and we are all here to see how best do we do our business better. So thank you so much. And now we are opening. Do we have microphones? We do. Perfect. We are now in plenary, and I see a hand there, and then second and third. Let's first do the three comments, questions. Where is the mic? It's right there. Can you just keep your hand up? It's there. Thank you.
Thank you, Honorable Chair. Thank you, Honorable Chair. Maybe I just stand up a bit. I appreciate the comments. Mine are just a few here. I'm thinking that maybe the time has come for us to speak to what we don't normally talk about. We are dealing with the crime that has been accessed into the system. We track it. I still believe we could have undetected crime going on in the background where nobody wants to look. Probably the sub-program should look at a way of conducting research in that dark area so that we could be able to explain probably why we still have mob justice. If we leave that area dark and we don't shed some light in that area, we may think and be comfortable that we are managing when actually we are having a disaster underground there. The second one, Honorable Chair, is can we have a deliberate awareness intervention in the prevention bit? Because here we are managing what has come in. But I think we still need a lot of passing on of knowledge and how people can be able to access our services and be able to know the procedures. I think we need in the budget to see commitment in that area by way of a percentage. If you look at the funding, how it is provided for, and you try to divide it according to what we are managing, what is coming in and what has not come in, I think that area, we can do so much in that area and save money for cases that would otherwise not have come in. And lastly, Honorable Chair, I am appealing to those who were not here when JELOS was starting. We had the popular 3 C's of communication, cooperation, collaboration. And somebody re-echoed them today. That was the backbone of establishment of the sector. Now, when judiciary went out of this access to justice sub-program, something else has happened. We are struggling to communicate. We are struggling to collaborate, and we are struggling to coordinate. And as you can see, the Chief Justice was an invited guest. He was supposed to be part of the real deal because this is access to justice. So probably National Planning Authority needs to look at this again. My suggestion is, isn't it possible to have the access to justice sub-program players come together in one program where judiciary is part, so that we can galvanize on all of those good things we have done and move forward? I just see a little bit of confusion. Thank you, Chair.
Thank you, Mr. Sekaja. And the next, next to her, just so that we get.
Thank you very much, Madam Justice, not Chair. One point I want to bring up is about the implementation of the National Action Plan on Human Rights. I think it's taken so long. We should look into it and see if it's possible to get it implemented. And the second one is complementarity of civil society. Civil society is there to complement government efforts and development and human rights issues and all that. I think the mistrust which exists between civil society and government generally should be resolved so that we can be able to work together and contribute to the development of the country. And lastly, people say that one bad apple spoils the whole basket or the entire basket. When we talk about administration of justice, have we gone to ask, what does the man on the street think? Here in law, when they were teaching us, they say, you measure by what the man on the street will say. But what does the man on the street say about the administration of justice and about what's going on depends on what is going on. All the good things which are really commended, all the good things which have been done by different organizations, access to justice program and all that, is spoiled by one thing: the illegal arrests, arbitrary arrests. Can we work on this issue? Because that bad apple of seeing people being put in drones is affecting the whole image of the justice system. I talk this because I work quite closely with the police, with the judiciary, with different institutions. They are doing a commendable job. But that one apple, bad, rotten apple, how are we going to deal with it?
Thank you so much. And there was, yes, Mr. Sewanyan.
Thank you, Chair. I'm Dr. Livingstone Sewanyana, the Executive Director of the Foundation for Human Rights Initiative, as well as the current United Nations Independent Expert on promoting a democratic and equitable international order. I'm going to speak more as the current United Nations Independent Expert on promoting a democratic and equitable international order, because under that mandate, I have been profiling member states on their governance and development practices. And under that mandate, I am required annually to exhibit or bring to the attention of member states best practices and challenges. So in that regard, I would like to bring out some positive aspects which I would like to commend you for, but at the same time also to bring out certain areas that are increasingly becoming a concern for Geneva and New York. The discussions we have in the UN General Assembly, in the UN Human Rights Council, these issues are featuring every other day. And sometimes I am very shy because being a Ugandan and being put to task to explain some of these issues puts me at odds with the mandate that I hold. Let me start with the positive aspects. One, I want to commend you for the improvements in customer care. I have actually noted there is real improvement in customer care. And more importantly, let me single out as well the immigration department at Entebbe Airport. We have taken note, even internationally, the way they handle passengers arriving and leaving. The time is so short. They have a friendly face, and I want to invite you to continue along that line. You join a number of agencies which we have always commended, particularly the Uganda Prison Service. We have always commended you for your professional approach, and other agencies which definitely I would be very happy to point out. Number two, I want to commend in a very special way Honorable Norbert Mao for having brought a human face to this whole sector. The engagements you have had have been noted, not only locally but also internationally. But more importantly, the innovation you came up with, the whole idea of having a cabinet standing committee on human rights is something welcome. But we would like you also, Honorable Minister, to ensure that it's functional, effective, delivers, and actually becomes a blessing to us all. The other aspect which I would like to bring out is the enactment of the Succession Amendment Act. I want to tell you that this act is very relevant to the public. I have had occasion to interface with very many people across the country. This is something they very much like, but Chair and honorable members, there is one thing. You need to sensitize the public about this act. There is an urgent need. As a sector, as this program, please, moving forward, please try as much as possible to sensitize the public, because there are different interpretations of that law, and it applies to so many people. As you know, the family is the best unit of society, and it affects that best unit, and it is very important, Chair and others, that people get to understand the dynamics of that law, how it applies, how effectively it can be put into practice. I now would like to bring out a few areas which I think remain a big blot on Uganda's human rights record. As you know, Uganda has just undergone the 3rd periodic review. The Attorney General just recently was subject to the Committee on Human Against Torture, and there are many other bodies looking at Uganda. But as the independent expert, these are my concerns, and also the concerns out there. One, and I think it has been mentioned many times, one of the biggest blots we have on our human rights record right now is the failure to prosecute the perpetrators of the November 19th and 20th killings. That issue is everywhere. Every forum we attend, every intervention, they are raising that question. What has Uganda done? First of all, we admitted as a country that over 54 people were killed during that period. However, there is no clear indication of how we have dealt with the question of justice and redress for those people. That remains a very big blot on our record, and I want to invite you to consider that issue very seriously in terms of moving forward. The other issue which I think we need to pay attention to, and has been raised by very many speakers, is the whole question of prison overcrowding. We have, of course, invested heavily in programs to decongest prisons, but apparently it seems it's a problem that seems not to be going away. And more particularly, I want to invite you to consider prison overcrowding in Western Uganda. When you generalize, of course, things look good. But if you go to Western Uganda, things are really terrible. If you go to Nyamushekera prison in particular, you will be shocked by the extent of overcrowding in that prison. People are crying out for justice and it's not being delivered. So beyond the generalization, let's look at some particular areas. One particular area is Western Uganda, especially with Shenya and those outlying places. There is a real problem. The other one, Chair, of course, I'm mindful of time, is the issue of the 48-hour rule. I think it is important that we invest more in ensuring respect for the 48-hour rule. And before I hand over this, one other thing I want to point out is that while we are dealing with the question of crime, let's try as much as possible to observe and uphold the constitutional guarantees. Definitely, we all must fight crime because there is no development, there is no progress that can go on without dealing with crime. But while dealing with crime, let's also have a human face. Chair, thank you so much. I am glad that I was able to attend this forum. I have not been in many of these forums recent because of the mandate I hold, because I have to profile 193 countries across the globe. Thank you so much.
Yeah. Thank you so much, Dr. Sewanyana. We are going to take just 3 more, and then we endeavor to answer this ourselves. We're just going to take 3 more. 1, 2, okay, and 3. Perfect. Thank you.
Thank you so much, Your Lordship. Going straight to the question, or to
your name, please.
My name is Mafundo Paul Katamba. I'm with NALO. The team is there. It is under the CSOs. Well, one thing is about communication, or how government organs can communicate. I guess an issue is we have a court judgment given by Kawale High Court. To enforce the court judgment, you must get clearance from Uganda Police IGP. It starts from execution of 2 million or 5 million. Get clearance from, to verify that, up to the root cause. It is, I've seen it as one issue that brings corruption. You find that these people that would, a case in point where people said, where there's a queue in 1 month, someone would say, I want it in 2 days. Someone has to come and clear that order from Kampala to RPC, to DPC, then security committee. This does not promote justice, does not promote access to justice. 2 is what Mr. Sewanyana said, the guarantee of the constitutionalism, like 48, like the 6 months upon when you're not committed. I think there's still a gap within the implementation where someone clocks the 6 months or is in 2 years, but you must either move court. That should be within the system, that some files that clock 6 months, the system highlights, or those files be forwarded for any implementation or subjecting it to having that person presented before court for bail or for any redress. Some of these files, I go to the route of the police still. The investigating officers. I've seen some files where we try following up. Of course, it falls under your office. The state attorneys are ready to work, but the file has statements that cannot disclose, well knowing that the facts are clear. People have the knowledge, but the statements were recorded in a lacking way. So I think, or I suggest that there is still an urge to teach the police officers who record statements, majorly in the CID department, so that we can have an improved or a better service delivery through the state attorneys and the judiciary. I thank you.
Thank you so much, Mr. Katamba. The next one was, okay, you bring, then the last one is here. in front here.
Thank you, Madam Chair. Protocol observed. My name is Tracy Kansime, and I work with NALO, which is a young innovation that's innovating about simplifying the law for Ugandans, especially the youth. Thank you for the opportunity to speak. I've had so many people talk today, and one thing I didn't hear about was innovation, especially around the legal areas, or the fact that young people should be a part of this discussion, or have representation here, or make a presentation or a recommendation up there. I have a question. What is JLOS? What are the partner organizations doing to enable young innovations be a part of the solutions you are garnering at this stakeholders table? Innovations are maybe a new thing to the legal system, but I know if applied very well, they will be able to bring younger people, and this will end up changing the narrative that is young people and crime, change that pattern to young people being a part of solutions, especially innovating around legal areas, simplifying the law for the youngest of children, to the youths, to the women, and everyone at the grassroots. Because if we keep talking very hard words and all these legal jargons, I'm afraid we're missing the people it's meant to help. What are we doing as development partners? What are we doing as JLOS to enable young people, empower women, empower children to understand the very law you are putting in place? Is it always about diversion? Also, when you talk about congestion, please take note of those in remand homes, especially for young people. So yes, I would love some views from you. Thanks.
Thank you, Ms. Kansime. We have the last one here. Right here at the front. Here. Okay, thank you.
Thank you very much, my lord. I'll be quick, and I'm making your work easier because I have two answers to matters that were raised. One was by the chairperson, Access to Justice Development Partners Group. He did mention that there was some lack of development on the law of recovering proceeds of crime. This is something we worked on at Uganda Law Reform Commission and produced a report, which report was then taken further by the Ministry of Ethics and Integrity, and principles were presented to Cabinet. Cabinet has discussed those principles and referred them back to the Ministry of Ethics and Integrity for some further work, and they will go back to Cabinet. So hopefully we'll have a bill presented to Cabinet soon, to Parliament soon. The second one was to Dr. Livingstone Sewanyana, who I cannot see where he is. He's on the other side, yes. You mentioned something about the Succession Act, the Amendment Act, and the need for sensitization. This is something we're taking up as Uganda Law Reform Commission. We're going to have some post-enactment advocacy, and it has been sponsored by the Access to Justice program, thankfully. We've received the funding just last week. So we'll be going on some advocacy. We've prepared the materials, they're ready. So you'll see more of that, radio talk shows and that sort of thing, because we believe it's very important. Thank you very much.
Thank you so much. Maybe you could also comment on Mr. Sekaja's, it was the first question. I don't know whether he was talking about research, that there could be something like...
Was that one on mob justice? That we should carry out some research on mob justice, on why
yes,
is it still there?
Something like that, exactly. And then there could be some crime that is really, like we should do some research on future crimes. What do you say about that?
That is something we welcome. We are happy to do that. We're in the business of research as Uganda Law Reform Commission. Thank you.
Thank you so much. I think now we have closed the questions. I am going to go to Dr. Sylvia to see what you can pick out, and then the rest of the answers will come from you. I'm just going to be reminding you what the different people mentioned, and if you're able to, like my sister did, you actually go ahead and answer. So let me start with Dr. Sylvia.
Thank you, my Lord. I don't know whether I have pressed some other button. Just to appreciate the plenary and participants, because mainly this session has been to add value to what would give on our side as our perspectives. Dr. Sewanyana has made justice, has given justice in adding. Madam Sekaja also added the voice to say that we are partners, civil society, and we complement government on what we do, but also we are cautious not to cross the line, and that one we are very cautious when we are doing our work. And we believe that if we continue the support and working together, we can go a long way. I've seen this under the many open days we've held across Uganda, where we convene and all the justice, land order sector come in and attend. From the judiciary, police, Uganda prisons, and others, Judicial Service Commission, when we are there and people are given to ask their questions, and the relevant representatives of the institutions are there, they clear a lot of gray area. So we need to leave the air conditioned and invest more into community sensitization, whether with the simplified materials, whether with going to the community and talking. One time, the registrar in charge of research at the judiciary recommended having a sector-owned media platform, because I think that is another area where we invest a lot of resources, paying media. But if we had one, it can work basically to do more sensitization rather than paying and going and paying for talk shows. So we need to go deeper into that. The lead of innovation, I think my Lord will explain what the sector is about, but she talks about innovation, and I must assure her that when we hear about automation, when we hear the work of URSB, all that is innovation. When we hear court automation, Proximus in the DPP, all that is innovation, but maybe they need to involve more of the voice of the youth and the young people. But also I want to note that we need to add more into looking at the grassroots. If we are automating, the other day in last meet we had what we call the paralegal referral database, case management and all that, but you realize that these paralegals have these other phones, which I don't know the name called. So it is very difficult to talk about smart apps when they have these other small phones. And the common man, the one who you are giving access to justice service, has that. So it is very, very important that when we are innovating, when we are developing systems, we customize them and come up with the alternative apps that can enable them to be able to receive justice. The youth, I think we did a research on access to justice for the youth in the justice land order sector, and we are able to get information of what the youth want to see. The youth currently look at the laws that we have, some of them as being archaic and not relevant to their times. So we need to keep reforming the laws, the procedures in court, making them as interesting as possible, as accommodative as possible, for them to be able to respond. And we have to be mindful that they are the majority in the custody. When we are talking about the congestion of the prison, the youth are the majority. So when we are designing programs, we need to look at their needs and be able to provide alternatives to justice delivery that enable them to access justice in the real time. So it's very, very important that when we are looking at reforms, we look at reforms across board. In my paper, I forgot to speak about, but I think the Deputy Technical Advisor and the CJ talked about it. Rationalizing human resource across the justice land order sector. Rationalizing resources that we give to the justice land order sector. I mean, if we recruit many judicial officers, but they don't have prosecutors before them, and if we build many buildings, and we have not taken their lawyers, we've not taken their judicial officers, we've not taken their prosecutors, the investigators have no resources. We shall remain in the cycle. We shall be addressing one problem. Digging, it's like digging up a pit and filling up another. We need the programmers, those that are doing planning, budgeting, to look at holistic service delivery that looks and leaves no one behind, and looks at all the nitty-gritties of access to justice, than looking at one component when we are looking at justice. My Lord, I can go on and on, but let me end here.
Thank you
so much.
Thank you so much, Dr. Sylvia. Is there anyone else who wants to comment on a number of things that were mentioned? Let me remind you, I don't see a hand up. Not a new question. Yes, commenting on what has already been discussed. Yes, please.
Thank you, my Lord. My name is Fred Ngavirano. I'm a Commissioner for Youth and Children. I just want to talk on two things. One, innovation. The Ministry of Gender with support from partners, notably UNICEF, USAID. We have come up with merging the GBV and the VAC, Uganda Child Helpline, and with a software even loaded on tablets for our social service workforce right away from the sub-county district. We are able to really guide the young people, especially children and the youth who are affected by the social ills we are all aware about. Again, on innovation, we support from UNDP. Uganda, as a country, now has joined what we call the Youth Connect Africa, with the headquarters in Rwanda. And our president, His Excellency Yoweri Kaguta Museveni, on 26 August 2022, he launched the Uganda chapter. And one of the innovations there is governance and the security, then the participation of younger people in leadership, dispensation of justice. And now as I talk, NIRA is working with ICT and our ministry to have a website for the youth, which will be hosted by NIRA. So with that, we believe we shall make a head-on in regard to dispensation of justice to young people. Lastly, I happen to be a member of the National Community Service, and I want to agree with Dr. Sylvia? Yeah. Last week, we are headed by none other than the chairperson of the Uganda Law Reform Commission, who is here, Dr. Pamela. She was representing our Justice Tadewa Simwe, and we visited Soloti. We found there, if I recall very well, 1,380 prisoners. And by looks, more than 80%, they were young people, youth. So I agree with the idea of research. I can stop on that. In regard, how do we decongest? Two things that came out from our field findings. One, the challenge of not having adequate number of resident state attorneys. Where we went, we went to Kumi, we went to Amuria, we were in Soroti. The issue is really a big challenge. From the informal sharing with some of those resident state attorneys, some of them, we studied with them, others were behind us at Makerere. You find one resident state attorney working 15 out of 24 hours, but things not shifting. I will not repeat the thin legs that Honorable Mao talked about. So we need really to balance the boat. As they said, we found some discrepancy in regard to facilitation, remuneration between the different actors in dispensation of justice. So we need to rationalize. Lastly, on the issue of corruption. I know my lane, but I want to say as a country, we need to do more than, you know, me are talking about corruption, and we single out only 2-3 MDAs. Myself, I'm struggling with even the people in my family. You get what you inspect, not what you expect. Everybody takes a chance of any gap. So the challenge is deep-rooted. I think the only way is to invest in our early childhood development, in regard to how we're bringing up the children. Otherwise, I have seen it. I'm likely to have worked even in civil society as a director, as an advisor. Even civil societies are not spared. Thank you.
Thank you so much. Thank you so much. I think, Ms. Kansime, you've heard there's really innovation everywhere in all the justice sectors. It's just maybe that it's not brought to your attention. And I really want to wind up this. I think there was a comment by Ms. Sekaja. You talked about the man on the street. I think I like that because sometimes we look at justice in a way that we think in the books. Yet actually, if you went around the country and you asked people what kind of justice they would want, you'd be so shocked at the answers they give you that maybe the majority may not even want the court procedures. They actually want the alternative justice method. So I like that. You talked, Dr. Sewanyana talked about, of course, the improvement of customer care. That's okay. The succession amendment. My sister Ebli answered that. Failure to prosecute the November death and many other cases that came up around that time. As the Office of the DPP, I'll be answering for the Office of the DPP, that we prosecute cases on evidence. That's what Article 120 says. If I do not get any evidence, and the fact that our law actually says the evidence has to be beyond reasonable doubt. So the standard is so high for criminal cases that it cannot be compared to the cases, a civil case where it is a balance. So for us as an office, if there's a case and we actually have, there's evidence, we prosecute. We only don't prosecute if there is an element of public interest. We can come in. Sometimes we have the law, we have the evidence, but public interest is that we don't prosecute. And please don't misread public interest to mean public wishes, because public wish could be that the person is actually handled by way of mob justice. That is their wish. That is not the public interest. That's public wish. So we don't go by the wishes of the public. We go by the public interest. So and then you talked about the 48-hour rule, the respect for the 48-hour rule. That's really, for us also, that's what we are trying to do now. That though we of course know that the 48-hour rule was put in place some 28 years ago, and crimes have evolved since then. You cannot say that you can have a case of terrorism within 48 hours. Otherwise, we shall be releasing everyone. It's not possible, practically possible. As we are in the trenches, we see that this 48-hour rule, it is something that we should have an engagement. We should have a conversation at another fora on this. Should we enlarge it? Should we be able to go back to court and enlarge it and say, give us more time, and then we come and give you how much we have done, and the court can say, okay, you can have more time? Or are we going to strictly just say 48 hours, and we must stick to that? But as it is now, it is the law, and we must stick to that. And we actually tell our investigators that we must stick to the 48 hours, and because going over that, then our cases are actually spoiled. The Office of the DPP does not like losing cases. We like to take cases to court and really have a successful conviction if the person is actually guilty. So we don't take cases to court. And you mentioned also something about the human face. Yes, as an office, we are actually looking at that bit, that the files that we receive every day, we are, if you really get, that's why my senior sister say that one bad apple spoils everything. We have prosecutors who are really hardworking with high integrity. And we really look at the files with the human face. When we look at these files, we are looking at people, a lot of, they're not just stories. These are real things which have happened to people and bad things. So at the end of the day, the office of the DPP can be taken like either we are just lazy. He already said it. We have now almost 1 state attorney to about 4 judicial officers running around all the courts. And then you have police will be waiting for you in office. Sometimes you come back at around 6 p.m. You find police waiting for you with the file. The suspects are in the cells. But you're not able to read these files. Tomorrow, the next day, the court is starting. It's only one state attorney doing a session. And before you know it, the 48 hours are done. So all these things we are talking, we're having this conversation, we should have that it is actually talking about there should be an ideal situation. It is ideal situations we're talking about. If it is 48 hours, which means the police, CID are well-resourced. We are talking about, Mr. Katarasambi, you talked about, Katambao, you talked about that the police have problem with recording statements and what. We are talking about a well-resourced police force in terms of numbers and training and tools. Then the office of the DPP is well-resourced. Would we really be talking about 48 hours? We wouldn't. But now we are having one state attorney handling 7 stations. And then the 48 hours cannot be respected, not because we don't want to, it is just not humanly possible at the end of the day. So I think those are some of the things that I saw. Communication, of course, the layers. That's why we are automating. Having so many people, Mr. Katamba, to answer to, that just breeds corruption. And we do it unintentionally. That's the one, sometimes even it becomes perceived corruption. Because then someone is tossed from one to the next, and someone says, I think they want something, that's why they're telling me to go to A, to B, to C. So when we do automation, I think we shall cut out most of these things, and the perceived corruption we shall get rid of. And I want to state this, since I have the chair, that the office of the DPP does not condone corruption, even among its staff. All I want is just bring me the evidence. I do not want wild allegations. I want you to bring me the evidence, because my prosecutors also deserve the same presumption of innocence that the rest of Ugandans are enjoying. So bring me the evidence, we shall prosecute. And we have about 3 of our own staff, senior level, whom we are prosecuting because of corruption. So we don't condone corruption. And with this, I want to end this session, and thank you so much, Dr. Sylvia. Yes, you wanted to mention something? Okay, just 1 minute, so that we close this session, because we have like 5 minutes for the minister to come. Just there.
Yeah, thank you, Madam Chair. I'm Assistant Inspector General Police, Ochaya James, in charge of research, planning, and development. I just wanted to add on what you have already alluded to, that the issue of 48 hours, like you say, has a lot of challenges. But as police, we are also doing something to ensure that some of the lesser offenses don't actually go beyond the 48 hours. For example, right now, we are redesigning the police form 18, which to us we think facilitate corruption. And in this form, we are going to have it carbonated for issues of accountability. We have also developed the anti-corruption strategy for the Uganda Police Force. We have also developed the Uganda Police Force human rights policy and a client charter. And we hope this will go a long way in helping us, one, reduce corruption and also improve on our image. Then secondly, the issue of statement recording, yes. We acknowledge we have a challenge there, but the current director right now is handling that together with the director of the Human Resource Development. He has started with the top management. Now he's going to the region, and later on he'll go to the district CID officer to ensure that the quality of investigation improves. Then lastly, we are now struggling to establish automation, which is the case tracking system. And once we have that in place, the director will be able to know which case is in Karamoja, which case is in Arua, who is handling the case, how long has it been in the system, and whether the suspect arrested has spent more than the required time. So these are some of the things that we are trying to put in place to improve on our services and the quality of investigations. I thank you.
Thank you. Thank you so much. I know that CID is undergoing a revolution, and in 1 year or two to come, it's going to be a game changer. We're going to see a huge difference. And with that, I think our session comes to an end. And I want to thank you so much for being very active. And if I did not pick you and your hand was up, I totally am sorry. Thank you so much, Dr. Sylvia. Thank you. I thought I should do this standing. Honorable Minister, it's my singular honor to welcome you back on the podium to make your concluding remarks and close this session. Thank you so much.
Having had a very successful event, I think I can now call you dear friends. So that we collapse these walls between their excellencies and their honorables and those with pips on their shoulders and so on. We have done it. It is here. Let's go and study it. Congratulations to those who have contributed to this. I consider myself the luckiest minister. First and foremost, I lead professionals. You know, I'm like a bishop. I lead priests. I'm also a priest. Because bishop is not a sacrament. It is really leadership. There's no special sacrament for a bishop. Even the Pope is a priest in the Catholic Church. At the end of the day, he's just a priest. So, I lead lawyers. I know how lawyers are trained. So I can assume. I'm also like in the police. You know how the police are trained. So generally, you know what to expect. Even in the military. I think it is the same for diplomats, at least those who go through the traditional path. Now, I'm also undergoing training. There are many things I'm still learning. And in many ways, all of you have been my teachers. I'm the one now standing between you and the lunch by the poolside. I hope it will not amount to torture. But I go back to the solar system. We serve one government. We serve one people. Of course, we all love flying our little flags. Minister of Justice, Police, UPDF. But at the end of the day, if we realize that we are part of the same solar system with the people at the center, and we all have our orbits, I think we can live with each other. It is actually okay for us to disagree.
in this program, what we should discourage is conflict. Not every disagreement should lead to conflict. We are going to review the Constitution. It is the biggest file on my desk. It will not take a long time because the proposals are all over the place. So those talking about 48-hour rule, come and persuade us. It actually depends on which side of the iron bars you are. DPP, the day you are on the other side of the iron bar, 48 hours will appear very long. It is a question of where you are standing. I have been on both sides of the iron bar. You know, I don't want to mention names, but the law has a way of making jokes. There is a reason why the 48-hour rule was put there. In some countries, it is even 24 hours. Maybe we will have to adjust it so that the hours depend on the gravity of the offense. But when we made the 1995 Constitution, we really felt free. We were like those animals in Animal Farm after chasing away Mr. Jones. They ran around all over the place. They even didn't want a government. They thought they could do it. Then they moved full circle. There was little restraint. Then we wanted to put everything in the Constitution. Do you know that our Constitution is 10 times the size of the American Constitution? So if constitutions were measured in kilograms, the Ugandan Constitution should be a very great constitution. Indeed, it is a great constitution, but constitutions are better left to be general. Once you go into too much detail in a constitution, you end up with problems. So, DPP, this is just to console you that we trapped ourselves, but we'll deal with that. Access to justice is increasing. The chairperson of the Law Reform Commission is very modest. She does not like to blow her own trumpet. Unlike us, politicians. We once had a president called Idi Amin. He went for an international meeting and he was praising himself so much. So you know the English, they try to be subtle. So they told him, Mr. President, you surely know how to blow your own trumpet. True enough and true to character, he reportedly shot up and said, no, I also play accordion. So let me play your accordion. That lady with her team, they have translated our Constitution into Braille, so the blind can now read the Constitution of Uganda. And it takes me back to Mrs. Sekaja's statement. The bad eggs are really making this country to look bad. But like one song says, even heaven has a rainy day. I haven't been there. I'm not in a hurry to go there. But I once listened to a song which says, even heaven has a rainy day. So if it rains in heaven, it doesn't mean it has stopped being heaven. It's just a rainy day. But sometimes you have seasons. Speaking as a politician, we are dealing with a difficult season. And we must understand that it is a season. In every country has cycles. Who would imagine that in the United States of America, people would go and do unthinkable things in the office of the Speaker of the US Congress? We had our own version in Uganda.
At least ours was not the entire parliamentary building. It was confined in the chamber. But in the one of America, they are investigating it. So, once again, responsibility of government is to respond. Whatever you are saying about what happened in November 2020, the killings, high-handedness of security forces, what I can assure you is, in the Ministry of Justice, we will not be part of a cover-up. We are getting tidbits of reports. They are not comprehensive. Some of the reports are scanty. Somebody says, Musoke of this village. Now, imagine in Buganda how many Musokes are there. But because over 50 dead bodies were there, even government is now tongue-tied. So, my friend Enanga, who has the thankless duty of having to be our mop. You know, we soil the environment, then he has to come and mop. I hope the Inspector General of Police will increase your salary. It's a very tough job. Citizens want to know where to complain. Actually, we must assume that there are people who abuse their powers everywhere. Abuse of power is everywhere. Even a gatekeeper can abuse powers. Personal assistants of ministers can abuse power. There's someone who reported to me that he took a letter to a powerful person, and the assistant looked at the letter and tore it and said, you know, there's nothing you can do about it. So, how do you complain? We must tell the citizens that even the boss has a boss. That's the magic formula. Because there are bosses who act. You may find a police constable who acts even with more authority than the Inspector General of Police. So we must empower citizens to know that there is a system of redress. I would imagine if one day, if we did an experiment, assuming the president of Uganda went and sat in a television studio and said, report anyone who has ever abused power in relation to something they were supposed to do to you. I think that would be a day of mourning. People will call and say, I went to this office, this and this happened. Citizens suffer getting land titles. Citizens suffer getting a file in the court. I'm glad the Directorate of Citizenship has dispersed those commission agents. You know, there was like a parade of people who would wait for you at the entrance of the passport office. They even claimed they had clients. They would say, your client is here, meaning you are the one to link them to the government you elected. So, I go back to the low-hanging fruits, the easy things we need to do. Most of the cases that come to me have very little to do with the job of a minister. Actually, 80% of the people I see don't need the Minister of Justice. They just need a decent man to give them straightforward advice. Now, to our donors, there's something I have seen in other countries. It is called Citizens Advice Centers. Many citizens just need good advice, but there's nobody to give them advice. Why don't we do some experiments in the cities? People want to privatize government. Cabinet directed us to set up a human rights desk at the ministry. We don't want to do the work of the Uganda Human Rights Commission. But people assume that we have power. Why do they assume that we have power? Because every Monday we sit in the same space with the President of Uganda in cabinet. To the extent that some people even want to turn us into messengers. Take this letter to the President. Actually, I have many such letters on all sorts of issues. Can you tell the President this? So, I'm the Minister of Justice. But sometimes people will tell you, the President promised this, but we are being blocked. So can we become plumbers? Because the system is blocked. And you know when it is blocked, the stench. So can we unblock the system? We should all become plumbers. It is not easy being a plumber. We need to unblock the system. We are going to put a hotline so that people can call. Because when you call the Ministry of Justice, obviously, if the Inspector General of Police finds a missed call from the Minister of Justice, chances of calling back are very high. Because you never know. The Minister of Justice may have a report when the contract is up for renewal at the vetting committee in Parliament. And I don't think anybody who is vetted by Parliament for another term wants the Minister of Justice on the other side, particularly this one who talks a lot. So we would then be able to say, we have got a call that somebody has been kidnapped. Use your cameras, find what it is. We are assuming that you are doing your job. You are arresting criminal suspects. It would be a tragedy for us government ministers to start treating every action by the police as criminal action. We want you to be free to exercise your powers and responsibilities. But we also want to assure you that when you stand your ground against anybody who wants you to abuse your office, we will defend you. That is the most important thing. I do believe that the contents of this report has assured our partners that all is not lost. Why? It is something in human nature. If I hold this paper like this and I ask you, what do you see? You are only going to see the spot. And yet the white part is bigger. Why? Because it is inbuilt in us. We are now going to have a buffet. The food will generally be nice, but there will be that food which may not be good. That's the one you are likely to talk about. The food was generally nice, but the groundnuts were burnt. And you will go, Munyonyo. No, they burn groundnuts. You will not talk about the air conditioning. You will not talk about the fish. You will not talk about that. So it has to be our duty to support the likes of Comrade Enanga. As a matter of fact, we want him to talk less. Let the political leaders who ask for votes talk to the people. Why should the spokesperson of UPDF be speaking about somebody arrested in Kabarole and you see Brigadier General Kulaije pleading with the media. I have called CMI, they said they don't have them. How can that happen? It should be the spokesperson of the Rwenzori region to talk about that. Mr. Enanga is at the national level. I want you to talk about Al-Shabaab threatening us in our peace in Kampala. That is your level. But Kataimbwa in my village in Amuro, let the one of us who are region talk about it. That way, you'll be dealing with the real big issues. Let us, the politicians, also face the music. Those will be my kind of statements when I come to meet the National Security Council. Because we see the burden is too much on you. We are the ones fighting for votes. We are the ones struggling for the next election. We are the ones who organize these parties. And then we say, Mr. Enanga is going to explain. Even cabinet ministers don't need to talk about everything. You are a very big person, Mr. Enanga. I know you are the subject of a lot of ridicule on social media, but they are your friends anyway. I think the day you keep quiet for 2 months, they'll really miss you and say, when is he going to talk again? But we want you to know that we keep up with the struggle you have. I believe that thanks to the work that we have been given as the Cabinet Standing Committee and Dr. Livingstone Sewanyana, I take your caution. We should not be another toothless bulldog that threatens. But let me tell you what the terms of reference of the Cabinet Subcommittee is. I mean, Cabinet Standing Committee. We are not supposed to replace any government agency. We are supposed to make it easy for Cabinet to take important decisions on human rights. Sometimes the Ministry of Foreign Affairs has to make so-called treaty reports, huge documents, and they are thrown at the entire Cabinet. And you know our Cabinet is not small. So then we start discussing it. The role of this committee is to scrutinize many of those things and then make clear-cut recommendations to the entire Cabinet to make a decision. But at the same time, we want to invite all of you to feel free to share information you have with us. It is very important that we stay connected to each other. We don't know everything. We depend on the technical people. That said, you have heard the Chief Justice. He is very militant about anybody trying to usurp the powers of the judiciary. You saw his reaction when our colleague went and sat on the chair of the magistrate. But I want to assure you, we are handling that one because the media fund it so much. You know, the media finds a small fire and they pour fuel until it becomes an inferno. But that's their job. It is not only in Uganda, everywhere. So we need to defend ourselves. We want the judiciary, those who are here, to know that we will not interfere with what you do. The DPP is a constitutional office. We have to be careful with constitutional offices, just like Attorney General. In Rwanda, the Minister of Justice is the Attorney General, is also in charge of investigations. Like in America, you have the Department of Justice is in charge of the FBI, the investigation wing. In Uganda, the checks and balances is not just about parliament and executive and judiciary. Even within this sector, we balance each other. And I think it should be that way. The prisons, we hope you'll allow more access to justices of the peace to tell people what is happening. And we hope many people like Mrs. Sekaja should be justices of the peace, if they are not. Being a justice of the peace basically means that you have a passport to enter any facility. And we believe they should be respected because on account of their responsibility, you earn that right. That way, if you hear that there is in Uganda they call them safe houses, then you can go there and people will tell you what is happening. We believe that there's a field we have ignored, employment rights. Workers are being abused. You are talking about politicians, but workers suffer a lot of abuse. I don't know whether we have any employment tribunals in Uganda, but we need employment tribunals in Uganda to protect workers. It is critical. I think I end by quoting from the Great Charter. The Latin version is a tongue twister, but it describes the qualities of justice. It should be free, because nothing is more iniquitous than sellable justice. It should be full, that is complete, because justice ought not to be limp. And lastly, it should be speedy, because delay is in effect a denial. These are the conversations that I have had in this room. And I think we owe it to ourselves to congratulate ourselves for working together. 27 years is a long time for jailers. You know, infant mortality rate of initiatives and organizations is very high. Infant mortality rate means a child dies before the age of 5 due to the 6 killer diseases: measles, diphtheria, whooping cough, diarrhea, and so on. Let us get a booster vaccine against those diseases that kill organizations. Looking around the room, I see people who are determined. Many of us here are holding new positions. So let us march together to the 28th annual report. I want to pledge my full support for the time that I'll be Minister of Justice. At least 3 years, you can be sure of that. At least, because it is good for you to know, because when I enter a place, I plan my exit always. And that eliminates a lot of stress. That way, I think those are also the years Jesus worked. Imagine 3 years only and the work he did. We keep reading about them. Every Sunday, people gather and they talk about that work of 3 years. So we actually have so much time to do so much good for Ugandans. We don't need too much time to do a lot of good. It's now my honor to invite you to join us for a sumptuous lunch. I have been told, I'm talking out of faith, which has been organized by the people who have been around us, the people who make us look good. Because from now, I'm going to take a lot of credit, you know. The Minister of Justice presided over. Sort of like a music conductor. You don't even play any single instrument. You are just pointing like that fellow there. Please stand up and I see you, the one pointing with a stick, you see? So he's the one who can say, now the drum, now this, now that. But it means you must have a very good ear. That means you really know music. So I know this music. And thank you for being such a great orchestra that have produced this wonderful music. My PS, thank you. Canon, where are you? That man is a canon of the Church of Uganda. Our partners, Dr. Kemsa and a colleague from the Austrian Corporation, they are only two, but somehow they are everywhere. Have you noticed that? Every function to do with this sector, those two ladies are there. I don't know how they do it. They are everywhere like MTN. Everywhere you go. Thank you so much for your commitment. We want to give you the assignment, together with the spokesperson of the partners, to mobilize the partners and tell them that we are still in love. The love is still there. There's no reason why we should fall apart. You are not serving a government, you are not serving a political party, you are serving the people of Uganda. Once we have that focus, we will be able to achieve a lot. And the disciplined forces, we will have our conversation. We can't talk a lot of our things here. It is important that we understand that. And then the various agencies that have come together, the civil society. I hope today I've given you the master key on how we can relate best with each other. I'll continue telling the politicians not to blacklist you, calling you enemies, calling you this. It is not good, because you may actually become enemies if we insist on calling you enemies. I believe as we go back, we are all energized. This meeting is now closed. God bless you.
Band, let us all rise for the anthems. Thank you very much. Let's put our hands together finally for the chief guest for the wonderful show we had today. And as ushers kindly guide our guests for the reception. And as we move, let's go remembering the words of Nelson Mandela when he said, listen with an open mind and seek feedback. Leadership and learning are indispensable to each other. Thank you so much. I remain Frank Baine, Commissioner of Prisons and Prison Spokesperson. One announcement. Somebody who went to South Africa has abandoned his keys. So if you know you went to South Africa, kindly come for your keys. The reception is at the poolside, right down here. Thank you very much. Of course, we thank the Secretariat so much for organizing this review, and we are proud of you, and we hope to benefit a lot from the report.